Hello there.
Hello. Hello, bitches.
Hello. Hello, chicken nugget.
Hello, everybody.
Hello.
All rise and like, subscribe, and bang the gavel, baby.
Sergeant Buzzkill, you know what's going on here. Order in the court. All right.
I'll take a pizza, maybe some fries. I like pizza and fries.
Oh, yeah, we're doing it live, Andrew. Good to see everybody jumping in. Hope your Thursday is going great. We got a case is underway. Live courtroom, live Zoom court drama unfolding in front of our very eyes. Colty's coming to court today. Hope that is all right. I believe that's against the rules.
Look, Creed, I don't want to sound out of school here, but my God, Johnny Depp looks like shit.
Johnny Depp really does look like shit. You're right. Glad you said that. FYI, and to any mods in here, when we get anybody that asks about what's going on with that, we cannot live stream that. We cannot restream the live stream.
We can go back and watch it after it's over.
We could if you want to do that, but
we can't.
Yeah,
while it's live.
So just know that
FYI.
we're not Court TV, and we don't even barely have a budget to make graphics. If you know what I mean.
Yes, barely scraping it together.
So there's that, and if you can reiterate that to anybody that says anything, so I don't have to say it 3 times, that's great. Johnny Depp definitely looks like shit, but this is the big murderer dude, right?
This is the guy who killed his wife and drove around with her body in the trunk for a while and delivered it to the police.
Yeah, he turned himself in with the body in there. It's a complete narcissist. Pretty crazy stuff. So we got some live stuff for you. We'll jump around a little bit. This one's very interesting. We'll try not to talk much. We're not lawyers, blah, blah, blah. I think I covered everything. That's about it.
That's about it. Let's go ahead and listen to this amazing accent.
No, I didn't read a letter, and it's legal mail. We're not allowed to read legal mail.
And you weren't instructed by anyone to hang around and wait for an answer.
No, I was not.
And his answer came just before you had time to walk away?
Yeah.
That's all.
Thank you, Mr. Hammond. You can be excused.
Can I ask one more question, Your Honor?
Remember,
No,
he's acting as his own attorney.
Just one.
And I'll let Mr. Wright have the last word.
And remember, his kids hate him.
Mr. Ammons, you said that you didn't see the letter. So once you showed me the letter, I didn't get to keep it.
It was in an envelope. I mean, are we clear on? It wasn't an actual letter. It was in an envelope, and the letter was inside.
It was a letter like this.
In an envelope.
No envelope.
But do we argue this?
Anyway.
How does this work?
Anyway,
I don't
what,
understand.
Mr. Hammond,
What-
just hold on.
what-
Mr. Belt,
The question.
you're testifying. Ask your question.
What happened to the letter?
I have no idea. I didn't take it.
Well, you left it with me.
Yes.
I don't have
Yes.
the letter.
Again, you're
I never had the letter.
testifying,
It's not
Mr.
my
Belt.
problem.
By the way, that was my
You're
fault. Sorry.
testifying,
The
Mr. Belt.
neighbor
And you
brought over
presented
the
those
check
letters
first.
today in your case in chief.
Oh,
Do you have any other questions of Mr. Hammonds?
This courtroom
So
is set up really
you gave me
weird,
this
too.
letter, correct?
It
You
is,
left
and
it
this
with me.
dude's
It has
just
an
standing
envelope with
there.
legal mail in it.
Yeah, he's
And it
testifying
was left
standing
with me,
up.
Correct?
Yeah, to my knowledge, yes.
As a suicidal, I could not have any letters. I could not have anything in my cell. Nothing.
Mr. Belt, you're testifying again, sir. Do you have a question for Mr. Hammonds? And you're well beyond the
Oof.
one question. So
This
you
is
get one
going to be
last
rough
question.
with him being his own
Any other
attorney.
questions for
I
Mr.
know.
Hammonds?
I mean, we saw the judge already being this way.
Is there any way to
Get him.
prove that you actually left the letter with
We
me?
watched it last time.
No.
All right,
Last time we watched,
Mr.
they were
Wright,
going
do you have
over
any
a lot
follow-up
of stuff with
questions?
him.
No, sir.
Yeah,
Thank
they
you, Mr.
were.
Wright.
Hello, Holly.
And he can be free and leave the
Holla,
courthouse,
holla.
Judge.
He can.
Thank you.
Hallelujah. Good to see you.
All right. Any other witnesses as to
Got his name
this
on it.
motion to suppress filed? His date of authoring is March 30, 2022.
Judge, we do have a couple of witnesses. They may be lengthy.
Okay.
And also, I'm going to ask the court before ruling at least to
Seemed very well
observe the
behaved.
video of the interrogation of Mr.
Let's
Bell.
see.
There's one at the beginning
Yeah,
and one at the end.
that's
I
one of the
press
things.
see you
And
Monday.
pertains to whether or not he
It's a,
invoked right to counsel.
emotional
at that
support animal,
hearing,
by the way.
so-
All right.
That's
It is
That's
allowed.
right.
Just so, then
Right.
we'll break for lunch, but just so. we
Ah.
Oh, come
understand,
on now.
How I intend to address the following.
How long we take it for
motions,
lunch?
Number 9 through
Guys,
14.
sit here and eat a
and
salad. I see it in
17
the
will
so
all be
guys eat
considered
steaks,
together. They
salad,
seem all
fine.
related to discovery issues. We'll next proceed after this motion with number 6 and 7. I will not consider number 8 until I've heard all the argument on discovery motions. And then
I want to see the
we
judge go
will
through that
address
door
then the
behind him.
remaining motions.
That's
We
hidden.
will finish this afternoon.
Carol
so that
wants
we
to
are
do
ready
a-
for jury selection Monday morning. We'll take a break and we will come back and start at let's start at 1:30. Give everybody enough time to get lunch. Thank you very much. We'll stand in recess.
Boy,
Transfer
busy.
all your funds over to me, Ulysses. That's the move. I'm just saying. That's the
Busy
move.
day over at Judge Boyd's. Creed's just getting caught up. I'm sorry. Here it is. A lot happening over at Stephanie Boyd's courtroom.
Good Lord.
Never see him stacked like that here with her.
We need a jury trial date.
Ulysses, keep us posted, buddy.
Yeah, that dude's insane. That guy, I really enjoyed when we got to watch the beginning of that a couple weeks ago.
All right, is this the jury trial date, Ms. Ferguson? May 17th? No, ma'am.
That was fun. So glad we had a chance to do that. Friday's going to be neat to watch that.
Mm-hmm. Stu's already told me he's gonna call me during the live stream. Ask me if I want to join in. He said, I said, what can I do?
It's the same thing as asking why we can't watch a UFC fight. The same thing as asking why we can't sit here and watch the Super Bowl. It's the same
All
exact
right,
thing.
your jury trial date, Mr. Figueroa.
These
is gonna be
people
May 10th.
pay to have their live on
You'll be
court
brought
TV
over
and stuff.
dressed
It's the
for
same
trial.
thing. The same thing. We can do it.
Deadline date
After
is not
it's
required. The court will
done
not
for the day
accept any
and it's not
plea
live
bargain
anymore,
agreement
sure.
after
But,
today,
you
but
know.
for a good cause. You'll be brought over dressed in whatever clothing you came with, whatever civilian clothing. you
Plus,
came
it's a
with to
long.
Bear
we're not going to
County
do any of these
Jail.
long
If you
cases.
wish
I'm
to
not
come
going to sit
in
here
some type
for
of different attire,
5 hours a
you will have
day
to contact your attorney.
with those
And
really
Ms.
long cases. You know what I
Valenzuela,
mean? Any of that
some
high profile
issues
stuff that takes
with
so
the
long.
Clothing exchange, let the court know.
We'd have to do like law talk with Mike and just do highlights.
Yeah, you do the highlights
Thank you.
from what
All right,
happened that
L8
day
will
to
go
sit there
back.
through
Yeah.
all that. I can. Unless it's
And Ms.
Casey Anthony. If
Valenzuela,
she
you're-
kills another child, we'll do what we
She's cute enough that Creed will sit through that.
Megan Enriquez.
that's one of the
Yes,
only
Judge,
ones
I'm
that,
still
and
gonna
I've
confirm
watched a
with
lot of
Michael.
Menendez.
Can I get a breakout room with Mr. Balboa, who's present in the courtroom?
All right. Let me see.
He's
What
noticed
breakout
Judge
room do you
Stephanie
want?
is in a different setting. She's not in her
Mhm.
little booth, but
That's true.
All right.
her
to the
purse
front.
is prominently
Perfectly.
displayed right behind her.
Well,
Perfectly.
Ryan Gordon is there.
Lynn, we've
got
been
breakout
so
room
lucky with
number
no
3,
stores. So I can
please.
tell all around us it's going to be
And
a
if
bad.
you could
Ryan
send-
Hall with
send
his
Mr. Balboa
900
to
hours
the-
worth of, I don't know.
Really hard here. Really hard winds right now.
Is there a Balboa in the courtroom, Brenna?
Is there a Balboa? Go out in the hallway. Ask 3 times.
Not typical to see Judge Stephanie with this many orange jumpsuits.
All right, he's going to be back at 2, Miss Enriquez.
Okay,
So-
I'll just log back
Shalom.
on. at 2 with him, Judge.
All right,
Thank
thank you.
you.
Hello, Gary.
Judge Joseph Acevedo, may I approach for a second?
Yes.
NASCAR fan, are you?
We have on hearing where you wanted to visit with the complainant before you decided whether you would set a bond to the agreed amount.
No, but I went to our gas station right down the road, by the way.
887.
Yes.
Talked
And
to the
physically
manager to get my receipt
across
about
from
my
your courtroom and the
got it
144.
taken care of. Creed the Karen.
It'd still be a while if I could step in there.
Your card wasn't
For
activated.
that matter, or if you.
No,
Yes,
it
are
was.
you able to come back
You
at
got to
2, Miss
ask them for
Acevedo, and we'll
things.
take
apparently.
you up
That's-
first thing.
If that's what your.
I must tell you
instructions
about
are.
this very quickly while they're just doing that. So I have $20 and 15 cents of points that you can use for anything. Then she opens it up and she shows the free fountain club, which I've earned 3 of, 3 fountain drinks. Then there's 5 fill-ups that I can do with 5 cents off, and then 3 with 10 cents off.
My goodness.
And I said, I don't know how you're even supposed to know that because you got to ask. I asked them to print out the thing with my card.
They typically don't give you a receipt anywhere anymore, just about.
No.
Especially gas
The
stations.
battery needs to be changed.
I don't know, but 187 is laughing his ass off.
There's Danny B.
Danny.
Talking about the We Got a Case channel. That's for those of you who hate everything else that we do. Eventually, we're all going to be over there. Same with We Got a Chase, but that's with time.
Hey, Jonathan.
Why is that so damn funny, Boyd? Judge Boyd.
Oh, that's okay. I mean,
Laughing
you know, a
at me.
lot of us need to change the batteries in our fire alarm.
Oh, the fire alarm was beeping.
Are you available, Ryan?
I can do it.
Considering how boring Live
That's
on
nice.
Patrol
Okay,
is,
Everybody's just saying, I'll do it.
that makes me feel bad. Means
All
we
right, the
must
court
be
is
really
calling.
bored.
Oh, that's okay. The court is calling.
Don't let him run down your favorites.
CR 2463 state.
I appreciate it.
Bob's a nice dude. I've said it a million times. I can't sit there and watch that.
For the state of Texas.
For the defense.
Nothing happens.
Jonathan Huerta.
And are you Mr. Huerta?
Yes, ma'am. Mr. Foresta.
Proceeding by video because of the pandemic.
What
Any
happened to
objections
everybody?
From the state?
None, Judge.
Any objections from the defense?
Oh, and breakout
Objection,
rooms
Your
also.
Honor.
Mr. Huerta, did you review a document entitled Defendant's Consent to
Yes.
Plea by Video?
It is
With your
leaving me
attorney,
alone
Did you
now.
understand it and did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video.
But where'd
Next,
they all
we'll show you
go?
What's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am. True.
Well, yeah, he has like a smoker's cough through that
Defense will show you what's
whole
entitled
interview
discovery
last
acknowledgement.
night.
Have you received all
Coughed
the
more than
discovery in
me.
this case? And did you review it with your client?
I saw a picture of him with cough drops
Court
with
will
him
find
in
that
the chopper
statement
today.
complies with discovery. Mr. Werchter, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? Did you and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Werchter, I'm showing you what's entitled
Damn,
Federal
Eric.
Punishments and Defendants Waivers and Affidavit of Admonitions.
That's
Did you review
interesting.
that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Wow. Yes, ma'am.
Did you understand you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you
give
and
me
you
more
won't be
than I
allowed to
bargained
withdraw
for.
your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Cock-a-doodle-doo.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
My screen
Yes, ma'am.
is
Did you intend to give up those rights and enter into
Covering
a
up
plea bargain
everything.
agreement in this case?
there. We
Yes,
go.
ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you
Yeah,
believe he has a
yeah.
rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he is currently competent and was legally sane at the time of the offense?
Fletcher,
Yes,
you
I
go
do, Your
watch,
Mr. Worth,
You go
has
watch
anyone
that and let me
threatened
know what you
forced
think.
You or placed you in fear to get you to enter this plea?
please.
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement? To
The
get you to
dude's
enter
nice,
this
but
plea?
my God, I just think.
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
He's going stringing
Did you review that plea?
Mm-hmm.
Did you
with
understand it?
Marcel
Yes, ma'am.
on Friday. We don't have any links or any times yet, but when we know,
State recommends
you will be the
deferred
first to know.
adjudication. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
Does she hustle bags on the side? You think maybe?
Yes, Your Honor.
Next, I'm showing you the paragraph
I
entitled.
mean, it
No.
is always prominent.
Did you
It's not
review
a
that
joke. I
paragraph
mean,
with
it's
your attorney?
she
Did you
does this.
understand it? Did you
On
electronically
purpose.
sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to?
Glenn, I'll make sure
to
to deny that 3
Written
times.
pretrial motions that have been filed.
Fourth, I'll
accept. By
accept.
the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement.
God, watch out, our guys on a
State
tear
is
today.
requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 150 hours of community service restitution, and the aggressive
and
driving.
real
force.
books.
But you understand that those are recommendations from the
Somebody
state.
sent her those and they
Not have
shouldn't
to
have.
follow those recommendations.
Oh, Angela, you mean the beeps?
the
I hear that
officers
so
charged with
often on
intent
these.
to not
I don't know anybody can live like that.
No comment.
State any evidence?
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
Any objections?
No objection, Your Honor.
Mr. Wirtz, I'm showing you what's entitled.
Hollywood Casino in West Virginia.
Stipulations. Did you review
It'd be a
that
great Easter.
document with your attorney? Did you understand?
I'm hanging out with family.
In all the appropriate places.
It's gonna be a
I'm
Yes,
gonna
sir.
be
You understand you have a
pounding
right to
cigarettes
choose,
and
right to use your
banging
attorney
buttons
to
all night.
examine and confront any
Maybe some horse
witnesses.
race.
State will call me the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, it will
We're gonna
not
watch that one today,
be
minus the
any
dog
live
issue.
testimony. Did you
Mhm.
understand?
We will not see the
Yes, ma'am.
dog.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
So stringing is when, and that's how Stu got his start. Those are people that
Right, after reviewing
go
states
around and get
exhibits 1 and attachments, the court will find there is sufficient
that go
evidence-
around and get live video of news things that are happening. They essentially become a news cameraman. However, there's a big difference between a stringer and dipshits like TW Live that drives around 300 miles an hour, beeping at people, telling them to move over, talking like a cop. There's a difference. That's a person that's not a stringer. So, you know.
Full house arrest for almost 8 months, and he hasn't violated. He's especially now that he's on these.
Why is he
probation,
nervous for?
We're respectfully requesting.
All right, Mr. Worter, who did the PT Cruiser belong to?
It was under my dad's name.
All right, so here your father is providing you with a PT Cruiser, and what you do is you speed in it, you evade the police, and you strike another car. Has restitution, I guess, been taken care of for that other vehicle that he struck?
I didn't hit another car.
Are you
I don't know,
sure?
That's what it said in the police report.
Nick, I hear you. I mean,
No,
God
I
forbid you had
didn't-
to
I
be
didn't
there,
strike another
right?
car.
Or God forbid you had to sit in here on Zoom and watch
As
this.
far
It'd be
as I know,
terrible.
there
I
was
get it.
no,
I understand.
How can I say
You're
it?
right. It says almost striking a vehicle parked on the side of the road. All right,
Almost,
so,
very close.
Is anyone allowing you to still have access to their vehicle to drive?
No, everybody usually takes me to go to do the weekly drug test, and then
Well, that
wherever I need
unfortunately
to
is
go.
not on my way to
All
New
right,
York.
so Mr.
Michael.
Workshop, I'm not going to allow you to drive your family's vehicles anymore
Yes, ma'am.
because you need to learn, and you need to learn responsibility. How old are you?
I'm 21, but I'll be 22.
All right, so you're going to be taking the VIA bus. If you want to drive a vehicle, then it needs to be something that you drive. When I was growing up, you could get a vehicle out of the nickel ad. Maybe it's $200, maybe it's $500, and
Nickel ad.
work on it, and you just drive it till it absolutely dies on you.
Yeah, what is she talking
Too
about?
many
And is that what we're
young
hearing? That
people
squeak? Is
get
that his
brand new
fan?
cars and
Could
other
be.
cars, and they have
What's
done
wrong with this person?
It's just like, here's a vehicle, go forth. So I'm going to help your parents with that. You understand?
Yes, ma'am. I appreciate it.
How far did you go in school?
Excuse me.
How
Front
far did
door.
you go in school?
Uh,
Graduate?
yeah, I graduated. Yes, ma'am.
What are you doing with the rest of your life?
Gary, I'm sorry.
Well, mainly right now, I just really just want to get back on my feet and start working, and pretty much just help my parents out for the meanwhile, since I'm here living with them and gonna be on probation. And after I get out probation, I'm wanting to grow as me as a own person, and start getting back on my feet. And
I want to take some
my
programs you need to say.
mistakes.
Well put.
All right, state.
That's a good
are you
answer.
Okay with removing the ignition interlock? I mean, removing.
Hopefully
the,
a week.
GPS?
Most likely 2,
Judge,
unfortunately.
State has no
Doug?
objection to that.
All right, this is what the court is going to order: 2 years.
Yeah, seeing the fans rough, bud.
$500 fine probated, 150
It's
hours
bad.
community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do that, 40 of those hours will be waived. Aggressive driving course, regular reporting by Zoom or in person. If you can't report by Zoom, you need to do it in person. Proof of employment within 30 days, no employment as a home health care provider or with minors, will remove the GPS. And the defendant, you are not allowed to drive any car that is not in your name. Do you understand?
Yes, ma'am. I just have one question.
Mhm.
Do y'all set like an appointment for I can get the GPS removed?
Probation will speak to you about that.
Oh, we're nowhere near the city, JG. That's 7.5, 8
and then
hours.
probation should
up
be
the
getting back to
thruway.
me within like
No,
Wednesday,
you're
right?
gonna talk to probation before we finish this.
Okay.
But I need you to listen to my instructions.
Yes,
You
ma'am.
are not allowed to
Didn't hit a
drive
car.
any vehicle unless that vehicle is in your name. Do you understand?
Yes, ma'am.
So from here on out, you're gonna be walking or taking the via bus, or somebody's gonna be chauffeuring you around. But you're not allowed to drive. Do you understand?
Spray a little double D40 on it.
How about we cut it off until we're
And
done?
You need to be in trade school
Close, shorty.
or in school.
About
So
an
I'm gonna
hour
order that, and if he
east.
obtains a certificate from trade school, or if he's in school, the remaining of the community service hours will be waived. There's gonna
Still
be,
within
based on
earshot
today's-
of 96.5
If you're drug
WCMF,
tested
though.
today, what the results gonna be?
I'm gonna be clean.
Okay, so we're gonna do regular UAs and field visits
No, I didn't.
one time per month.
Where
Rebecca,
does
is
he
there
live?
anything else he
Over
needs?
on Lake Wiley?
No, ma'am.
Oh,
Mr.
Trotman
Huerta,
area.
is there anything else you need from the court in order?
No,
to be
I'll look
successful?
later. That's interesting.
No, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your
No.
attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
All right,
Kinda
because this is a
laying my
bargaining
grandmother to
agreement,
rest
by
and taking
following
care of
the
her
bargaining
house.
agreement, and because you
Quite
waived
the
your right to
opposite,
appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Nothing
All right, good
sexy
luck,
about that.
Mr. Huerta.
No.
Mr. Huerta, you got a lot of
Not at
growing up
all.
to do.
Yes,
And
ma'am.
part of me helping you grow up is you need to start paying your own way.
And
All
stop
right?
driving a PT Cruiser.
All right, good luck to you. I'm gonna see
You can get a car and the nickel
Number
ads.
one,
Creed,
probation
come
will
on.
meet you
I
there and
love
go over the
that.
conditions
It
with
is
you.
so old
Okay.
school. Those are the ones that you'd see,
Mr.
like the papers that would be
Cuellar,
like at the
you go to
gas
work out room
station or the,
number
where you get your
186.
coffee.
Yeah.
basically.
We'll go to the room and then we'll leave from there. Thank you.
All right, thank you. Let me
Good,
find
Jim.
where you are, Mr. Cuellar.
I have the.
Hell yeah.
Already.
All right, thank you.
Thank you, Judge.
Judge, I'm back.
Oh,
from
there they
breakout
are. This
room.
is so interesting how she jumps between
Ms.
this.
Sosa, the state needs to upload some more videos.
That's maxed out, right? You can't get any
and
bigger.
On Ms. McGuire, I have an offer.
They could
I
put two more people.
set up a visit with
Well,
her,
yeah, I mean, but
That's it.
Go over the offer.
All right, Ms. Sosa,
That's it. That's as big as it
is
gets.
there a reason your video?
oh,
was
thank you
off?
guys.
Miss Sosa.
Yeah, it's gonna be a crazy 2
All right.
weeks.
Ms.
What do you
Sosa,
got
we're gonna have
lined
to
up? We
start
don't care
hearing
what
your
Miss
question.
Sosa's doing. Where we at here?
This is Your Honor, Michael J. Nelson from Mystery Science
Oh.
Theater. We only see the tip of his head.
Okay.
He's been, I don't know what he's up to be
I can
honest.
find it.
Oh, thank you guys. Yeah, she did. She's 90 something. Right after our wedding, actually. So
I'm sorry.
I said right after the wedding. I thought I was pretty clear with that.
No,
not hear me?
Judge.
Oh, okay.
Judge Michael Nelson can't hear too well.
Oh, okay. Thank you. Sorry, I'm
You can't
carrying on
figure out how to
business
get the
with my
camera
assistant.
right.
Sorry about that. Let me review this.
Judges, it's almost like you can almost pick out what judge is what from the way that their camera angles are. If you
Mhm.
think about it, like Judge Simpson's is the same. What's his name over there at Genesee's? Same.
Yeah. Is Stephanie Camacho trying to be seductive? She's like got her finger in her mouth and
The baby always representing some Hornet stuff too. I love that. Trotman is 77 North. I'll have to look it up. No.
come at me. We got a whole 100-yard football field, bud.
Those are so ugly.
A baby hurts. Jeez.
Well, it used to take us like 7 or more. But you're right. You got to drive down in. Plus we always would stop in Atlantic City too. There's that.
This judge is when we talk about people running tight courts, he does not. He can't get his own self right, let alone any of these people.
Angela, thank you. Because Facebook needs, there's like no court on Facebook whatsoever. People need to know.
Like Steven here, he knows, right, Steven? Oh, he's not talking today. Whoa! Whoa! Easy. Easy. Settle down. Settle down. Have you seen any of the OnlyFans stuff he's doing? I'm
Oh
interested.
no, I'm sorry. That's a rabbit hole I don't need to go down. But
I
we
left,
did watch.
I left that chat immediately as soon as she started talking about it.
Do you think? Yeah. But yeah, we did watch him drive. I remember he was at the Buckhorn, as I always call it, in Dansville. And then we watched it. We stayed on that day when he was on. Went right through that little town I grew up in, which is just crazy. How dare he? Blasphemy. Well, lots going on around here. I might fish around for another courtroom.
Yeah. We come over here and everything died. Is he got a mask around his chin, Corey, or is that a beard?
That's a very nice beard. Let's see what Monica Purdy's got.
Miss Purdy.
Miss
Purdy don't know.
Talking about several weeks before trial. He then shows up to trial pro se, and as a result, the Supreme Court of Texas makes the decision that, in fact, a continuance should have been granted. The second case out of the Supreme Court, which is the Crane case, I think is also very much.
Thank you.
Still good law. I think both Villegas and Crank are good law here. In that situation, it was an issue about licensing, and Dr. Crank was
Dr.
here,
Crank?
again, similar to the situation with Mr. Spangler.
Crank it up.
He decided he wasn't.
Dr. Crank.
He decided that he wanted to fire his counsel, and so he did it. And as opposing counsel pointed out, it is true the timing's a bit different.
He's done this
does it
before.
in the middle of the proceeding or on the morning of the proceeding.
No,
rather
you're
than
cut off,
doing it
Fletcher.
several weeks
Nope.
prior.
No more
But
dibs
it's
for
a
you.
distinction without a difference. At the end of the day, the question, the central inquiry that the court is asking is, how do we determine fault? And in that situation where the facts are that it was the litigant, the party who decides to fire counsel, which are the facts here, even on the record, the new record as has been supplemented today, then the court makes the determination that is not valid.
I'm guessing by the way she's talking, that's her actual court, or that's her actual
For the
office.
continuance was through no fault of that party. As to the court's specific question, well, what about situations? Because this must happen all the time, human nature. There are folks out there, they don't want to go to trial. And so in those situations, how do the courts look at it? I would actually point the court to a case that was cited by the plaintiffs here in their motion. It's McKinney versus City of Cedar Hill.
Yeah, I'd look right at Alan and say he's a pretty
2012
lady.
case, but
So
decided by the Fifth
glad he
Court
put
of
that.
Appeals there in Dallas. And in
I'm
that
punch
case,
anybody that puts that on there. I'm
there
sorry.
is a recitation and a summarization actually of law that deals with this very issue. And here in that case, first of all, the court determined that it was not unreasonable for the trial court to have granted the continuance, but cites very importantly to the kinds of cases I believe Your Honor is looking for. Cites to the case of JP at 365 Southwest 3rd.
Did you say JG?
at pages
She is
832
too much like a real
37.
attorney over
And in
here.
that case, the
We're not
court
used to
had
seeing this
determined
level
that
of
the trial judge
professionalism
had
around
not
here.
abused discretion by denying a continuance.
I got Steven over here who's an attorney in his car.
Litigant had fired his attorney 1 month before trial. Okay,
That's
so
what
now
we
we're
usually
getting much
used to.
closer to our set of facts. Another case in this summary by the McKinney court is
Must be about $1,000 an hour, huh?
Hollenbeck at
Oh, at least.
695 Southwest 2nd.
Sarge, thank you.
There,
And 5,000 an hour on the weekends.
not to have abused discretion when a continuance was denied.
If Flusha
when
claims
that
any
litigant
other,
fired his attorney
just
4
time him
days
out for
before
300
trial.
seconds. He's not
So
allowed to.
what I
None.
would submit
No
to this
more.
court is that there's now sort of a whack-a-mole situation a bit. But no matter whether you want to look at the record as it stood on April 5th when the court was first asked to hear a continuance motion, or whether you want to look at the record as of call it a couple hours ago, under this new reply and declaration submitted by Mr. Spangenberg today, the result under Texas law is the same, which is that there has been no showing here by Mr. Spangenberg that this continuance is through no fault of his own, because either under the record on April 5th, he failed to pay his lawyers, either he failed to meet the requirement to pay the bills that were already due, or he failed to pay the retainer that was required. Again, express representation.
She don't have any
by
kids that get in the
counsel
way of work.
Speaking for Mr. Spangenberg
She and a
to
mom.
this court on April 5th. Or alternatively, looking at the record today, Mr. Spangenberg decided that
Thank you,
he
Fletcher.
was unhappy with his counsel. A short period before trial, he decided that he would fire counsel, similar to in the JP case, decided to fire that
The
counsel.
firing of counsel is
At the end of
crazy,
the
though, when you
day,
think
the
about it.
counsel who was representing Mr. Spangenberg was Wick Phillips. Yes, of course. Everyone's got their chosen horse. I mean, and I think, Judge, you're right. I would be concerned.
Is that
and
a
I would
mask
wanna
on
know
Brandon,
where
or
my
is that
six
just a
figures is
beard?
going as well.
The
But
beautiful,
the reality
beautiful,
is
rich, dark
that the
beard.
facts here don't suggest that there were no good options for Mr. Spangenberg. Amy Laval, to be frank, Your Honor, I mean, Mr. Tilton's firm, through our arrangement, was largely handling the pretrial work. We never interacted with Amy Laval. But to the extent she was supposed to be lead
Maybe he's
counsel,
got nice
come in to
moves.
try the case. Mr. Nelson had taken over that case 6 months prior to
Hey.
this special setting. And the
Hi.
only reason we point out that
Hey.
Mr. Nelson is on the website is we don't have any other facts besides the record that was presented to all of us on April 5th, and now this supplemental record that has been attempted here today. But we do see
That's
from the website, Mr. Nelson still is of counsel. He still holds himself out. The firm holds himself.
I could
himself
listen to this
in
girl go
out
on
as
all
an
day.
attorney for the firm who is
I would
available.
hire her for anything.
Whatever that circumstance.
You
that
wouldn't
was
if you had to sleep with her every night, and this is her. And
even fast forward
Huh?
Oh, she does this in her sleep, no doubt.
by mid-March, 6 weeks before trial, we know, in fact, that Mr. Baum had already appeared on behalf of Mr. Spangenberg. We were already receiving.
By the way, when the judge comes back, we have somewhere to go to.
Baum. We
Check out
also
this bunch.
communication
Oh,
that was referred to
God,
earlier
yes. Okay,
from
nice,
Keeper
nice.
as to whether or not
Ensemble cast.
Yeah.
conflicted or whether or not a
If
conflict could
if Lisa
potentially
stops
be
talking by then, she
Again,
probably
Mr.
won't.
Baum
Take a
was
breath.
still representing as lead counsel. It looked like it was a
All these guys hate her, right?
I don't know, but everybody's screwed. That's all I know, Nancy.
6 weeks before trial. And so to have a situation where you're talking about
She's filibustering
more
like a
time than
mother.
the JP case, which is 4 weeks before trial. 1
Even the
month
judge
before
ain't
trial.
saying anything.
Mr.
Just let her
Spangenberg,
go.
who, as this court knows from the
She'll
last
run out at
hearing,
some point. Huh,
filed
Billy?
more than 1,600
Billy.
lawsuits. in a
Steve's gone.
period
Steve said
of
enough.
Just 5 years.
I don't
under
blame
his
him.
Old venture IPNAV. He is very familiar with litigation system. And so I would turn that statement around. That also indicates under these circumstances, he could have, had he wanted to, had he in fact tried or made the efforts that he should have, he obviously could have brought in Reed Smith, who has been longtime transactional counsel to him, instead of waiting. And you got to think tactically waiting until after the April 15th.
Imagine her up against
right after
Meg
the
for
April
something.
15th
God, would that
to
be
go
great?
And then to contact his longtime counsel at Reed Smith and say, hey, could you connect me with your best trial counsel?
I just know
in
that they're
Dallas?
losing. She's
Why did
winning.
That conversation occur
Yeah.
in mid-March at the time that he met Mr. Baum and realized Mr. Nelson would become unavailable at the time of the special trial setting. I think when you put all those facts together, Your Honor, that there is no other
Yes.
fair result here, or one that meets the requirements of the law. The burden simply hasn't been met, and the motion for continuance should be denied, Your Honor.
All right, thank you. Mr. Johansson?
Yeah,
final
just
word?
stop. She
Yeah,
won.
Just a couple of comments, Your Honor. And
Good luck, Mark.
certainly appreciate the
I say
enthusiasm,
good luck.
and vigor of Ms. Sy and her response.
The
to
vigor.
the case longer than we have. And I know she mentioned her opening comments, when does this?
Mark's a
circus
loser.
stop? This is not a circus. I mean, this case is not even 2 years old.
Yeah, it's not
This would be a
circus.
much different situation if there had been, 5 or 6 continuances, which has happened in many cases I've been involved in, and just that's not the case here. It's less than 2 years old.
right now.
My God, look how big that coffee. This is how big that coffee mug was.
I spoke about the facts and the law.
So
regarding
man's
the
mug.
facts argument she made, you know, and I guess in support of the argument that there really was a quote payment issue that is the fault of Mr. Spangenberg, she relies on apparently.
That's all he got.
Mr. Baum
Defense,
said that,
you know.
every element of Rule 1.15 has been met, e.g. or i.e. non-payment. It's important.
BRB, somebody's at my door.
You go ahead. EG or IE. I like that.
The nature of the payment dispute at the hearing. He was vague about it and he did not disclose the nature of it. So there's no evidence in the record of, you know, this speculation that the Wick Phillips retainer agreement may have required this retainer. So
There wasn't a representation about the payment issue, other than I do distinctly remember it being told to the court, if we are to stay on this case, we will be trying this case for free. That is what was told to the court.
Oh, wow.
Okay. Well, I can't respond to that. I wasn't there. I haven't talked to Mr. Baum about that. All I can tell you is what we believe the unrefuted document evidence is that we've submitted today. We've shown an invoice that shows zero balance as of March 15, except for new billings, $2,600 at that point, and Mr. Spangenberg's declaration that says they wanted a six-figure payment. I wasn't willing to do that when I didn't know this person and I wasn't sure I wanted to be by counsel. Your Honor, the bottom line, we think this squarely falls under the Vajegas versus Carter case. And again, yeah, the facts are a little bit different. Trial. That's what we were from the Texas Supreme Court.
Welcome back, Creed.
And the cases that were cited, McKinney versus Cedar Hill, the JP
Enjoy that.
LaChance case, none of those cases involve parallel facts that like we have here, where two prior counsel on their own withdrew, where that is absolutely no fault of the party, and then where a new lawyer was appointed by the law firm, and Mr. Spangenberg, if he was here, would tell you that was the only lawyer that was offered to him, that was available at Wick Phillips to try the case, and under those circumstances, he's entitled to.
Perfect timing. You missed a long Creed frame.
And as inconvenient as it is,
my dog. Oh my God.
Including us.
I'm gonna be in court next.
Including the court, including Miss Sy.
What happened?
Her clients.
Mailman's outside. I'm trying to
get
get packages from the mailman.
That we be allowed adequate time.
Dog comes running.
Dog
and
hauls ass out there. This guy freaks out. Starts fighting my dog with the package. Knocking him back.
Or fault on the part of Mr. Spangenberg.
He falls in the yard.
He has met the Vajegas standard, and Your Honor, we are re-urging and respectfully requesting.
You're going to be in Zoom court soon.
Continuance to allow us to adequately prepare for trial.
Is your judge back?
Yeah, we're back over here.
All right, let's do that.
I
Was
just
a
want
great.
to make sure that we're all on the
looking
same
cast.
page. We also have a contempt matter, actually,
Oh,
I think
Elsinore.
4 contempt matters that we have to deal with as well.
There's that fence.
All right, Ms. Enlow, with all that in mind, I'm holding up a copy of the pre-sentence report right now. This report was produced by the Department of Corrections. It's been supplemented. You've had a chance to discuss that report with your attorney, Mr. Connolly, correct?
Yes, Your Honor.
Okay. All right, Mr. Connolly, are there any changes that you'd like to propose to the body of the report or challenges to the scoring?
No, Your Honor, I believe, without commenting on the new additional pages, I believe the original report to be accurate and the scoring to be correct, Your Honor.
All right, thank you. Ms. Muggenberg, let's go to you. As to the original report or the supplement, do the people have any changes they'd like to propose or any challenges to the scoring?
No, Your Honor. Thank you.
All right. The department has requested in their supplementation that
My turn for an
OV-19 be
dog tag.
scored.
Go ahead.
OV-19 reflects, well, let me start with you, Mr. Herman. Mr. Herman, did you have a score in mind? Were you requesting 10 points for interference with the administration of justice?
Yes, Your Honor, that's what the department would be seeking for OV-19 on the listed dockets in the case report.
All right, let's go ahead and go through that issue. Mr. Conley, do you have any argument with regard to OV-19?
It's already scored, I believe, in all but one of them, Judge. Unless I'm missing something. I take it back. Two of them don't have it. So, and the basis for that would be the most recent conduct would be interference with the administration of justice prior to sentencing.
The information that was laid out in the
Yeah.
two-page supplement is, I think, what they're basing that on.
Yes, Your Honor. I would leave that to the court's discretion, Your Honor. I've never, to be honest with you, this would be the first time I've had that happen while somebody was pending sentencing incarcerated. So it's something I have not previously dealt with.
Can anyone tell me what that is in Matthew's wall up there? Is that a wild boar or a dog? What exactly is that on his wall back there? The defense, Mr. Matthew Conley.
All right, do the people have a position with regard to the scoring of OV-19 on the two charges where it hasn't been scored at 10 points? That would be 13980 from 22 and 13751 from 21.
Your Honor, I believe based on Ms. Enlow's most recent behavior, that is appropriately scored at 10 points. And I would ask the court to adjust the scoring on those two files.
All right, well, based on the information provided by the department in their supplement, it is clear by a preponderance to the court that Ms. Enlow did, in fact, seek to fabricate her admission to Munson Medical Center through a fabricated attempted suicide, and in doing so qualifies, I think, certainly for 10 points under OV-19. That is an interference with the administration of justice, and I find by a preponderance based on the information provided by Mr. Herman that scoring is appropriate. OV-19 is rescored in both files 13751 from 2021 and 13980 from 2022. Let's start with 13751 FC. That takes our total OV to 25. Can someone help me with regard to how that affects the scoring?
Your Honor, that would raise the offense variable level to an OV3, and the guidelines go from 12 to 24 to 14 to 29.
Wow,
all right, Mr. Conley, you agree with the math?
I do agree with the math.
Okay, let's look at 22.
I don't.
-13980 FC.
I agree with this math.
That takes our total OV to 26, which brings us to I believe an OV3. What does that do to our guideline range?
Thank you, Billy.
Oh,
Your Honor, again, they would go from 12 to 24 to 14 to 29.
Again, Mr. Conley, you agree with the math?
Yes, Your Honor, I do.
All right. And one more thing before we continue, and that is the consecutive status of file 14003. We had a discussion at a previous hearing regarding this matter and at the plea. Can the parties re-advise me as to exposure regarding consecutive sentencing with regard to all 5 matters that we have pending before us today?
I think, well,
did you guys all just hear that big breath that Rachel up there let out? Is like, she's got 5 things pending against her, all bad. Everything seems like she's in a lot of trouble. So go ahead and get your guesses on what you think our good friend Rachel has been up to.
Ms. Mogenberg explain it, Judge. I think I know what she's going to say.
Thank you.
Your Honor, my understanding is that it would go by case, not by charge. So anything committed after, well, so 13751, there's no consecutive.
Gary.
13980, the sentence can be consecutive to 13751. 13981 would be consecutive to 980, and 14003,
enough.
the two charges would be concurrent with one another, but
Got to be
consecutive
talking about Rachel, right?
to
Yeah,
981. So I
She's up
believe
there
the
been letting
court
out some
could
huge breaths.
stack all of the charges with the exception of the two in 14003.
And that's all discretionary consecutive, is that right?
That's correct. That is all discretionary consecutive.
All right. Mr. Connolly, you agree with that analysis?
I do, Your Honor. That was my understanding, that it was
Retail theft.
stackable and discretionary, as Ms. Mogenberg has indicated.
Okay, thank you very much. All right, with that, we've had a chance to go through the language of the report and challenges to the scoring, and there are none beyond what we've already discussed. Let's go to the people. Do the people have any argument regarding sentence, or are there any victims that wish to speak in this matter at this time?
Your Honor, I believe there are victims watching, but there are none that are here to speak at this time, but you do have the reports or the impact statements from several of them that I'm sure the court has had an opportunity to look at. Frankly, in this case, Your Honor, I was prepared to argue for consecutive sentencing when we were back here
God,
2 weeks ago.
Yeah, no.
And there was a small part of me that felt bad
Here
because
you are.
Miss Enlow was obviously someone who was an addict, and she was continually released and committed new crimes. When that continued to the point that she was reaching 4 or 5 new felonies, it's hard to feel bad for someone at that point. And the last escapades, for lack of a better word, have simply solidified my opinion, at least, that she needs to be incarcerated for as long as possible. She has will do
Noelle's not a big
anything
fan
to
of Rachel.
avoid accountability. Everything seems to be someone else's fault. This last, false suicide attempt, leaving Munson, a false report against one of our officers. These are all things that were harmful to public safety and that cost the county many, many man hours trying to bring her back. She is truly the example of making a mountain out of a molehill. Whether or not there will be additional charges, there's certainly ground for that. To some extent, that will depend on her sentence today, but I would ask the court to sentence her within the guidelines, but to use that discretionary authority that you have in this case and to stack her charges so she is out of this community for a long period of time. Thank you.
Lots to watch.
Thank you, Ms. Muggenberg. Mr. Connolly, allocution.
Thank you, Your Honor. At the initial sentencing, Your Honor, I don't think it was unrealistic that she potentially could have gotten local time in treatment. I know that that wasn't a given, that it was a straddle cell. But I had some hope, at least the initial sentence, that was possible. I'm really kind of, I don't know, I'm just frustrated and I just can't figure out what happened here, Judge. I tried to explain to Ms. Enlow, that she wasn't in that bad of a position. At the previous sentencing, that I was concerned about what was happening, and obviously something worse has apparently happened, which has gotten her into a whole other ball of trouble. I understand the recommendation now for a prison sentence, Your Honor, based upon the current conduct. The question is, how long of a prison sentence, Judge? I guess I would ask you to consider.
Do you think that Damon
sentencing at the
feels
top
really
end
out
of
of
the
place since
guidelines,
he's the
but
only
not
one without a
stacking the
beard?
charges? That would certainly give her
He has cutting
prison
eyes.
exposure for
Some
the
good beards
crimes
in
that
there.
she's
Yeah,
being
does have
sentenced for today. None of them, I guess to explain them, none of them were the worst of crimes, Your Honor. They were addict crimes. They were obviously, there's victims, and the victims need to be made whole, but it was clearly addict behavior. She will have to be sentenced
some
court on
earlier.
Saturdays and Sundays,
at some point
so
on the
yeah.
conduct
We'll
that
see.
occurred when she was released from the jail, but that's not necessarily what she's being sentenced on here today. So I would ask that Your Honor consider holding whatever punishment you feel is appropriate for that, for the sentencing that's likely to come down the road for purposes of today, not stacking the offenses, Your Honor, but staying within the guidelines. And Obviously, I'll leave it to the court's discretion as to what portion of those guidelines are appropriate, but given the most recent facts, I understand it's probably not where we were 2 weeks ago. So that said, Your Honor, I mean, Miss Enlow is a desperate addict and she behaves like one. Again, I'm just really disheartened
Nothing
to
good
see
to say about her.
where we are today as opposed to where we could have been. So
My
I
client
know
is
that she knows what
a
she
piece
did
of
is
trash,
wrong.
Your
I
Honor.
know that she knows that when she's
You know what a
using drugs, her
POS is,
behavior is
Your Honor?
inappropriate and that
That's
she's
her.
leaving victims and creating problems for herself and her family. I'm just hopeful that at some point she turns the corner and decides that it's not worth it, that this gets her nothing but trouble. And she really does. Instead of simply saying she needs help, she really needs help. So
she's a menace.
At this point, I hope that she takes advantage of whatever resources are made available to her.
Can we hear
through the
from
state,
Rachel? By any
to
chance?
try and get this under
I would
control,
love
Your
to.
Honor, because it's no way to spend the rest of your life as a young woman and a mother being incarcerated.
Oh, great. She's
All
a
right,
mom.
thank you, Mr. Connolly. Before we hear from Ms. Enlow, let's make sure we have the jail credit right. We had
Thank you,
initially
Mr.
planned
Elson. I
on
refer
conducting
listening
a
to me.
sentencing on the 1st of April. It's now the 14th. Does that mean that we need to add 13 days to each of the jail credits here? Mr. Herman, I'm looking to you.
Your Honor, I believe it should be 9 days on each docket. She was back incarceration on May 5th. Jail credit would go till the day before sentencing. I counted it to be 9 additional days.
All right, so with regard to 13751, the jail
fine.
credit is
She'll
108.
make it.
With regard to 13980, the jail credit would be 102. Same for the remaining.
Does she even have much to say, you
4
think?
or 3 matters.
I'm sorry.
Is there any objection
I
to
need
that
help.
recalculation?
No, Your Honor.
No, Your Honor.
Okay.
Can I
thank
go
you,
to
Mr. Herman.
treatment instead of the
All right, well, Mr.
stony
Enlow, or
lonesome?
That's what I was wondering.
Ms. Enlow, now is the time for you to address me if you'd like to, before I sentence you on these files. I'd be glad to hear what you have to say.
Undress you with my eyes, Your Honor.
All right. So this is probably gonna open up a can of worms, but this is just the truth because I don't know where to turn. Obviously, in like my last bout of behavior, this is what happened. There was drugs in the jail.
I
had
want you,
relapse in
hold on,
jail.
hold on. I need you to stop for just a second, okay?
You see how old
I
the
have
court
2 things to
reporter is,
tell you.
Rachel?
First, you have to slow down. We're making a word-for-word transcription of what you say. I know you're nervous, but I can't get it down if you're speaking very quickly, okay? That's number one. Number two, I also want to warn you not to say anything having to do with matters that may be charged coming up, because those statements can be used against you here in court. Do you understand that?
Yes, Your Honor.
Do you need to speak with your attorney about that?
No, Your Honor.
All right. With that, Mr. Conley, did you have anything else that you wish to advise your client of?
Just to mirror your sentiments, Your Honor, Miss Enlow, do not talk about anything that happened
the stuff
between the last sentencing date and today. You will be incriminating yourself. So I
I
advise
was
you not
drunk
to
in
discuss
jail, I
anything
believe
that
was
happened
her
between
first
the last date
line.
and today.
All right. With
Yes.
that, Ms. Enlow, I want to hear what you have to say, so
Poor
please
court
continue.
reporter. Do you see her? She's just
I mean, I guess quite frankly, Your Honor, like the addict part of me wanted to sit around and think about what I could say or what I could do to try to get some mercy for you, talk about my kids, this and that. But my kids aren't martyring tools to gain your mercy, for one, because it's them that need sympathy, not me. The only best decision I've made for them 3 kids is that they're placed with my parents and they're safe. Even though that was a hard decision, I did it. You know, there's 4 dates in my life that I remember. My kid's birthday in August 20th, 2005. You want to know what that day was? I got in a
Sure.
car accident, got prescribed Oxycontin,
well.
and my life's
Kind of
never
trippy.
changed. That December, I went to the doctor and said, hey, when I stop taking these pain pills, my stomach hurts, this and that. Their answer was, we'll just keep prescribing you medicine. That turned into a heroin addiction. That doesn't in no way, shape, or form excuse the countless hours I've caused Miss Moenberg, the countless hours I've been through the court.
No.
There's not no justification for habitually offending when I know right from wrong. I'm not handicapped. I do know right from wrong. I do have some mental health issues that I've never really faced up until recently. But this is just this is just the truth. I got high in the jail. It led to a spiral downhill out of control. into the escapade, as Miss Mullenberg would refer to it as, which it was.
She's moving
Um,
fast. She's on speed
There
now.
are victims in my crime, and whether they're a part of my wrong behavior or not, they're still victims. And if things were taken from them or lost from them throughout the course of it, it's still wrong. You know, in my head, I used to justify it as, well, I'm getting high with them, or they're becoming victims, even though it's all bound into the drug life behavior, da, 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 da. That doesn't justify me, and I can only speak for me today. This is what I truly believe. Okay, probably earned myself a prison sentence. That's fair to say. That's where I've grown up, in prison and in jail. And this is my honest opinion. I would go to prison. I'd probably have no misconducts. I'd come back out of prison at my earliest parole because I'd earn a parole. But you want to know the truth, Your Honor? Is I'm going to go there and there's going to be drugs right there in abundance. There's going to be people, because I grew up there, that I can get drugs from in every unit on the prison grounds. Just like, unfortunately, is in this jail right now. You know, when I used to come to this jail as a teenager, it used to save my life. I graduated high school from this county jail. I believe it's in the state that it's in right now, not
So
to
she's
any
an
officer's
alumni.
fault, just because that's how bad things are getting out of control. So I don't know the answer either, because I've been to prison, I've been to these places, and I can see everybody's point of view. But I guess what I'm asking you for is, at 35, I'm asking for help, because I don't know the answer either. If God came down and asked me today, would you give your eyesight, which would mean I would forfeit ever seeing my kids or my family again, and trade it for my addiction, I'd do it. If he asked for my legs and he'd take away my addiction, I'd do it. That doesn't make anything right, though, but I don't have the answer either, because if I did, I wouldn't be sitting right here. I'd be at home. You know, this last time I went to prison, I came out, I did great on parole. I got a job, I had a family, I had 2 kids with no CPS involvement because I wasn't using. I got married, but here's the whole thing. I was a drug addict that married a drug dealer. So eventually things spiraled out of control. And guess what happened?
Good choices.
Here we
Match
are.
from heaven.
Here we are. And I really thought I had it that time. I had 4 years sobriety, no parole violations. I really thought I had it. I don't like being the laughing stock of this place. I don't like being the joke. I don't like that my 60-year-old parents are chasing my 1-year-old son. I've never even seen my son walk. I called home the other day, and rightfully so, anything that you guys can say to me today is going to hurt, and I earned it.
Changed a
But
lot.
nothing hurts more than to hear my son call my mom, Mom. Because I'm his mom. I just haven't acted like it. So I haven't earned that name. My 8-year-old grew up for 3 years coming to a prison visiting room. Those things hurt worse than anything anybody's going to say here about me today. If I don't make it out of prison before my dad dies, you know the last thing my dad said to me? He said, get out of the car. I'm going to hug you, because chances are you're going to kill yourself
Is
or
the court
earn
reporter
yourself
about
a
to cry?
10-year imprisonment, and I won't see you again. That's the last face-to-face conversation I had with my dad.
Yeah, because she's so behind typing.
So I guess at this point, Your Honor,
I figured her
to say that
fingers
I'm
hurt.
scared of prison is a lie. To say that I haven't earned it all is a lie. And I don't know. I don't know either. I don't know. I guess I would ask you to help me. And I feel like I'm a perfect example of
Sounds like they've tried to help her a lot.
incarceration and rehabilitation. That's just the bottom line. Me without drugs isn't a bad person. But the
just a
fact
lot
of the matter
less
is
fun.
that I've done bad things, and it's affected a lot of people. So, but the people that I'm worried about are Aaliyah, Serenity, and Frank, my son, and my daughters. Because they're
Them
the ones
3
paying the
kids that
price.
she
Their
referred to
dad's
a minute
back in
ago.
prison, their mom's going to prison. And my 60-year-old parents, I don't have no excuse to be like this. I have a good mom and dad. Yeah, there's arguments and there's this and that, and there's things I haven't dealt with. But man, they raised me, my brothers and sisters, and now they're raising their grandkids at 60 years old when they shouldn't have to. So nothing you're gonna say to me, or however long you're gonna sentence me, is gonna hurt worse than when my daughter blows out her birthday candles next week without me, or the fact I haven't seen my son walk, or the fact my 8-year-old is just flat out pissed at me, and rightfully so.
That's how strong drugs are when you think
So-
about that. That's crazy.
I
If she
don't
just
know
took a
either.
birth control pill,
I'm just
she
as
would
frustrated as
not
everybody
be
else.
in as
because
bad
I
a
don't
way
know.
right now.
I don't know. I just want it to go away. I wish I could go back to that day and never be. I hate that doctor. I hate him. I hate him.
Blaming it all on the doc. I mean, I understand that. I get
All right,
that.
Ms. Enlow.
But to blame all
I
of
want
that-
you to know first that I'm not a dispassionate actor here. I have a family member who's in the very same situation, who was in a skiing accident, broke his femur, was prescribed OxyContin at a young age, and has had nothing but addiction trouble ever since. Great kid, great young man now, but in and out of jail, going through the same things that you're going through. Maybe not to the extent that you've gone through, but still working every single day to beat addiction. Great family. I'm not saying that because it's my family, but because it's good parents, good people who care and love him very much and want the best for him. But he's going through it. So I don't sit here not understanding what's happened to you. But the challenge I've got is I have to sentence you based on your behavior. And you're right. What you've just said to us is as frankly clear a statement of someone in your situation as I've ever heard. It's not what I expected from you. And you took responsibility. That's appropriate. That's important. You expressed some remorse for what you've done to all of the people who are here just trying to do their jobs and the extent to which you've manipulated them.
Well, I
And
can't
that's-
imagine what Ms.
Hold on,
Moberg
hold
had
on.
put in.
You're done, okay? Now
Quiet.
it's my chance to talk. I understand. You don't need to say anything else. I don't want you to say anything else because I think you've really said it all. And you're right. There are a lot of people who, in your own family, and people who show up at work every day here in the jails, who work at Munson, who've been victims of your crimes. There are a lot of people out there who've been affected by your behavior. And this may all well trace back to that initial opiate prescription that you got. That doesn't surprise me. I've seen it many times before. I've seen it in my own family. So I understand. But the challenge is you do have to pay the price. And there is a price to pay. I recognize that there are drugs available in the MDOC. I recognize, as you know, there are sometimes drugs available here in local county. It is a choice, though, that you're going to have to make, and it's going to be a difficult choice at each and every step. I have never been addicted. I don't know what it's like, but I see hundreds and hundreds of addicts, and I feel for them. I really do, because you may get high once, but then every time you're using, it's really chasing that first time. And in some cases, it's really just trying to stay level. I understand. But that, as you said, rightly, does not justify the behavior that you've engaged in. And we need to talk about that because a prison sentence is appropriate given everything that's gone on. I really want you rehabilitated. I really want you to have the kind of life that you've talked about wanting to have. But clearly, at this point, I can't order you to do that. Mr. Herman can't supervise you in a way that will make that happen. Mr. Connolly's best representation won't be able to make that happen. You're the only one who can do it. There's just no one else. And you seem to be willing to try. I'm glad to hear that. I'll put you in the best position possible for that. But I want you to understand, even though you've, I think, spoken eloquently, even elegantly today, that doesn't minimize what you've done. The price has to be paid. All right. Before me is Rachel Enlow. She's a 34-year-old woman. She's here with her attorney, Mr. Connolly.
We haven't seen any compassion.
He was
from
appointed in this case.
judge
for
yet,
these
so that was
cases.
pretty interesting.
She's here because she pled guilty to 5 different files, 4 different files, 5 different charges. The first is 21-13751 FC. This is a false pretenses matter between 1,000 and 20,000. It subjects her to a maximum of 5 years in prison. She has 108 days of credit as against any sentence I impose. The guidelines are 14 to 29 months. In charge 2, and that is file 13980 FC, The conviction was for unlawful driving away of an automobile. That is also a 5-year felony here in the state of Michigan. The guidelines there are also 14 to 29 months. She has 102 days of credit as against any sentence I impose. In charge 3, the conviction is in file 22-13981FH. It's
No
for
way.
tampering with an electronic monitoring device, a 2-year felony. The guidelines are 5 to 23 months. Her jail credit is 102 days. And she was convicted in 2 charges in file 22-14003FC. The first is retail fraud, first degree.
I got
It's
one
a
of them.
5-year felony. The guidelines are 12 to 24 months. She has
But I mean,
102
she
days
runs
of
the
credit.
gamut of like,
And
she's
in
got like
count
20
2,
charges
it's
against her. so-
receiving and concealing a stolen property, being a motor vehicle, also a
So
5-year
property,
felony.
I said it
The
in the chat.
guidelines are 12 to 24 months. There are a series of other matters, including habitual notices that were dismissed. Pursuant to the plea agreement, they are dismissed at this time. She does have some pending charges out of Kent County in district court. And as I've noted, she was on bond sort of in a cascading way after the first charge was levied in 2021. Her prior convictions are significant. She has 6 prior felonies, 14 prior misdemeanors. They are not, frankly, all that unusual for someone who is an addict. If we look
Picking 'em
back
up.
at the last 10 years, beginning
I
with
agree.
file,
Listen to all these charges, though. It's a lot, but I get what you're saying. I totally
beginning with
understand.
file
Keep in
14
mind,
to
some of us make
26,
some jokes here. and
we
there,
have a
too.
stolen property receiving conceal out of Grand Traverse County. She served jail time there.
The
And in
list of these
2012,
charges.
in Leelanau County, there was an attempted larceny. She served prison time in that matter. There was also a home invasion matter that was dismissed at that time.
Home
In
invasion.
2012, in December, there was a breaking and entering with intent matter. She was also served, sentenced to prison time in that matter out of Grand Traverse County. There was a driving while license suspended matter, a minor matter, misdemeanor.
Why has she
out
not
of
gotten
Grand Traverse
charged?
County in 2016. Also in 2016, however, she was convicted of maintaining a drug house. She was sentenced to 12 to 24 months in the Department of Corrections.
Maintaining a drug
She was
house.
given consecutive time, consecutive to her parole term.
Me too, and the Mountain Dew.
And in, let's see. Then that takes us to 2020, where we have the instant offenses that we've been discussing. As I indicated, there is an outstanding matter in Kentwood relating to resisting and obstructing a police officer. So again, a criminal history that is consistent with someone who's deep in the throes of addiction. And that's where she finds herself after all this time. Looking at the crimes one by one in file 13751. She was essentially involved in soliciting funding from an organization
look
called
that
Love Thy
bad.
Neighbor.
Call that a trap house.
She received cash, gas cards, money from
Listen to
the
this.
credit union, and was lying about the basis for the need for this information. She received money for a hotel room. She lied about needing money to finalize a trip
Stealing from a charity.
from Mr.
essentially,
Enlow.
right?
The bottom line is, again, acting as an addict. She was saying whatever she needed to say in order to get help from complete strangers. And ultimately, this resulted in an investigation, and she was charged with false pretenses and convicted.
Now,
this was an
in
upscale
file
drug house.
13981. Pardon me.
I like a good sweet tea.
13981, the
Clayton
defendant
County,
was on
court coming
community
up next.
corrections. She had a
The dude's on
GPS
a
tether.
bus on a
She
Greyhound.
removed it without approval.
That's a first.
In file
Pop it back up,
13980. She was involved in stealing and concealing and driving away a vehicle owned by her neighbor, Ms. Kimes, a 2011 Chevrolet Cruze.
Not the Cruze.
In file 14003.
Yeah. Said when I was a teenager in jail, it was much better. It's been going on a while.
Yeah, she graduated from there. Yeah, yeah. She was the kind of person that had the
She was involved
personality
in
that
theft
needed
of
didn't need
property
those
from
pills.
Walmart.
Oh, not the Walmart.
Seriously, what has she not done?
She's done it all.
On or about January 3rd of 2022.
Well, at least we made it to January.
Make that
now, this
December
year.
21st, 22nd of 2021.
She's moved up.
Could I buy some pot from you?
And also in possession of a 2007 red Dodge Nitro that had been reported stolen.
Nitro. She really is.
So there certainly is support for each of the charges that have been filed against her. The court would also note that there was certainly support for the contempt findings that the court entered. Those are 93-day misdemeanors with regard to each of these files. The question before the court is really how we resolve this matter in an appropriate sentence that accomplishes several of the goals the court has.
Seriously,
Number
what do you
one,
guys think in
it's
the
protection of
chat?
public.
What's she gonna get?
The situation that Ms. Enlow finds.
Yeah, he's gonna have to hit her hard, right? I mean,
I mean, even if you dropped half of the cases, you're still looking at 10 to 20. No, I mean, some of it is just inexcusable.
I'm saying 5 years.
Do you think that he's going to do like a suspended sentence and send her straight in to get help, or are we going to do some hard time then help?
Hard time for sure.
There's the
He's gonna
dude right
have-
there.
he's
He's
gonna have
literally on a Greyhound bus right now in court.
It could be a private plane, Creed. You don't know.
finds herself in right now.
I'm
is
guessing
one
10
where
with some help.
she is not afraid. There's no social limitation on her to do whatever is necessary in order to continue her addiction. Again, the court empathizes with her situation, but that doesn't mean that I can simply ignore the fact that she manipulates others in order to accomplish what she thinks she needs. And that creates damage in the community, and it's something that the community needs to be protected from. An appropriate amount of punishment, therefore, alongside is appropriate. But I'm also concerned about the rehabilitation here. And I do want to give her whatever opportunity we can in order to accomplish that. She's right about the Department of Corrections. She's right about the local jail. And that's because there are drugs available, illicit drugs available everywhere in our society, everywhere. You're never going to be in a place where you're going to be away from them. So the bottom line here is, as I said, despite what any of us try to do to help you out or to punish you appropriately, you're the one who's going to have to make the decisions. And we aren't going to be with you when that happens. So it's going to be completely up to you.
How is that possible, JJ?
So all of those things together and all of the discussion we've had today convinces me that an appropriate sentence here would be one that includes a significant prison sentence. I want her to have the chance to clear out if she can. I want her to have an opportunity to make good choices if she can, and eventually to be perhaps paroled out. And hopefully by that point to have an opportunity at a quality life. But again, it's going to be completely up to her. She'll have the time to think about it. And my hope is she makes the right decisions. I will note in each of these sentences that I would like the Department of Corrections to pursue appropriate therapies for addiction. I know that there are different programs that are available. They're not unaware of the need for this programming. And if it's available, I want you to have it. All right, it's the sentence of the court with regard to file 13751 that you will serve 14 months in the Michigan Department of Corrections. You have credit for 108 days that you have already served. It's the sentence of the court with regard to file 22-13980 that you will serve 14 months in the Michigan Department of Corrections. That time is consecutive to the time in count 1. And that's 14 to 60 months as it is in count 1 as well, 14 to 60 months. It is the sentence of the court with regard to file 22-13981FH that you will serve 5 months in the, strike that. You will serve 12 months in the Michigan Department of Corrections. You have 102 days that you've already served. That will be credited. That sentence is concurrent to file 13980. It is the sentence of the court with regard to file 22-14003FC in count 1 that you will serve.
Is he going down each one of these and posing a sentence on each one?
On each
rather
one.
than just-
You will serve 12 months to 60 months in the Michigan Department of Corrections.
12 months
That
to 60
sentence
months.
is consecutive to files 751 and 980. It is a sentence of the court in count 2 of file 21-143003 that you will serve 12 months to 60 months in the Michigan Department of Corrections. That sentence is consecutive to file 751 and 980. However, both counts in 14003 are concurrent with each other.
Can you pause that real quick?
Mhm.
Even though it's live, I want to pause that really quick. So I just want to, just so we know, as he continues on with these, a consecutive sentence. If the judge orders the sentences to run consecutively, the total prison sentence is 5 years. They're using this as with some numbers, but anyways, you serve count 1, 3 years, blah blah blah. Concurrent. If the judge were to order the sentence to run concurrently, the defendant's sentence would be 3 years. They were using a bunch of, damn it. So that
So
didn't really-
basically, if they run concurrently, they are, if you get 12 months for this one, 12 months for this one, 12 months for this one, you're not getting 36 months.
Right.
You're getting 12 months because you're going to
Right.
serve for all those at the same time. But she is in for at least 12 months to 60 months on several of those charges. And that's a huge freaking window. 60 months.
Yeah.
My math isn't great, but that's a lot.
I always
5
get
years?
those two mixed up. So a little bit better.
Consecutively means, one after the other after the other.
Right.
You get done with one, then you start the next one.
Hopefully at the end of it, he
A final
brings it all
tally.
That will
back.
mean that the total sentence that you will serve in terms of consecutive sentencing, as far as the court is concerned, is 40 months to 60 months in the Michigan Department of Corrections. 40 months total as a minimum in the Michigan Department of Corrections. Each of the counts
40
in
months
751, 980, and 14003 are a
I
maximum
get it.
of
It's a lot
60
of
months.
math happening.
Of course, file 981 has a maximum of 24 months. Now, there are some fines and costs associated with this matter, and those are the minimum costs that are required by law to be instated. Those include a $68 state court cost in each of these files. They
She'll pay that when she
include
gets
a
out.
$130 crime victims assessment in each of these files. And any other
Hard time,
mandated
baby.
state costs, including DNA testing if necessary, in each of these files as well. No other fines and costs will be assessed. I want the defendant in the best position possible when she is ultimately released. The court is going to sentence her in the contempt
They were all stolen.
violations to time served in each of the files. So 108 days in 751.
We've learned
102
anything.
days in the remaining 3 files.
Work your programs.
Yeah,
Oh,
do
yeah.
they even drug test in
No
jail?
additional fines and costs with regard to the contempt
Seems like they
citations
might
as
want
well.
to.
Are there any questions regarding the sentence, beginning with you, Mr. Connolly?
No questions, Your Honor. Thank you.
Ms. Muggenberg?
No, Your Honor, thank you.
All right. Ma'am, you
wanted
do have the
more.
right to appeal the conviction
think they
and
both did.
sentences that I've just imposed
To
in
be
all of
honest with
these
you.
cases. You also have the right to the assistance of an attorney to prosecute those appeals. If you can't afford an attorney, one would be appointed for you at the public's expense. But if you'd like to appeal, you need to let Mr. Connolly know that within the next 42 days. If you don't ask for that appeal within the next 42 days, it's waived. Do you understand that?
Yes, Your Honor.
All right. How many days do you have to contact Mr. Connolly?
42.
Ms. Enlow, I really wish you the best of luck
That
going
escalated
forward. I hope
quickly.
this is the last time we see each other. Thank you.
Thank you.
As good as I can do.
Judge Osmer.
Yes, thank you, Ms. Campbell. What can I help you with?
Yeah.
On file 13981 is the max 24.
It is.
Wow.
Okay.
Well,
And then I
that's
just have
that.
one more question.
Yes.
On the contempt charge for all the cases, does that account I should be adding to each judgment? Because right now I just have like what she was originally charged with on each judgment.
What I'd like is a separate misdemeanor conviction notice, because that was the conviction. It was for a 93-day misdemeanor. Or it can simply be a separate notice of sentence with regard to a
Sentencing
misdemeanor
got a
conviction. They're all misdemeanor
Big
convictions.
break, I feel, anyways.
Yeah, she absolutely did. I mean, especially if you could have, this lady down here, she wanted her to max out on everything.
Oh, yeah.
She wanted
Yeah.
the hit her with everything you got, Judge. And it's like, would you feel like she, got it the way she should have if that was your car she stole or all this other
She
stuff?
stole a lot. She stole from charity. She did a lot. Like he said, I love that because we haven't seen that side of him yet, the compassion part. He's the same guy with the fence at the at the American Legion. So that was pretty interesting to see that. I love seeing a real side of judges when they can talk about things that have happened in their own family.
Oh, yeah, he brought that up. I was shocked by that.
But I'm also shocked at the same time that he's not imposing any treatment centers or anything like afterwards.
I mean,
he's
he's expecting her to get clean in there, and it seems like there's no chance of that happening.
Absolutely. Listen, we're going to jump into whatever's happening here at Clayton County. We're a little over an hour into this. Appreciate you guys joining us. We do this 5 days a week at 1 o'clock East. Live Zoom court. We never know what we're going to see, what we're going to hear. Some days a little bit boring. Some days are nothing but banger after banger after banger. One really quick thing I wanted to do. This actually sums this up a lot better about the consecutive to the concurrent. It says a consecutive sentencing plan is where a court imposes 2 or more terms of custody time, and you serve one term immediately following another. A concurrent sentencing plan is where you serve all the sentences at the same time. So when
that's what you want,
with the prisoner being released after the longest term ends. So
Yes.
that other way that other one I brought up to explain is
It's gonna happen. You just have to accept it.
Yeah, I don't want that.
we need the clip of him talking about how bad electric cars are in Teslas, and then
Ms. Thomas said you
showing
have an email address, so I'm just
Tesla.
gonna have the clerk send a copy of your sentence to the address we have on file.
Okay.
Okay.
Is she on a bus too? Look how her background's shaking.
All right.
Unless you had.
No,
I was just saying you're free to go unless you had any questions for me.
that's it.
All right, thank you.
Well, he's a liar, Eric. It's $1.25. Tell him to get out and about once.
Address because the address.
I wonder how accurate they are, though. I mean, do you get what you pay for? Hope he's back. Creed, if you want to, I also have first appearances going over here.
Yes, ma'am, Your Honor.
Yeah, not a lot
Started
happening
out
here.
as
We
a
can
janitor
just
in
see
a-
what's
in
up.
a
in a school, and now he's worked his way up to the teacher, and he's trying to get a master's. So we want to try to keep his record clear. And quite
He was
frankly, I
a
think it's
janitor and
case
worked
that
himself
at a
up to
judge
a
trial,
teacher?
we'd have a very good chance of getting him not guilty. It was a
Right on.
judge. It was an accident that he fell asleep, hit somebody on the way off the road, didn't realize it. The police came in contact with him, asked him, do you know you got in an accident? He said no, and they all went to a gas station. He met with the guy he hit. They got along great. His insurance is covered.
They're going out to
everything.
lunch later.
I don't.
Sharing chicken sandwich together. I'll be RB.
Hasn't affected him. I don't know that a withhold would, because he would have been adjudicated guilty of that. But that's entirely up to y'all. So it sounds, do you want to have time to talk to him and possibly come back later this afternoon, or do you just want to schedule it for another court date, Mr. Weaver?
I mean, to make it, like for me, it's simple. Like I said, I'd rather keep my record clean, because like I said, I am starting over my career. I've taken a long journey, so.
The offer today is to pay a fine of $308, withhold adjudication, meaning no conviction on your record.
Right.
To be paid within 60 days. If you're looking for a straight dismissal, the state's not prepared to do that today. But I'm not saying we won't be prepared to do that at some point, but we're not prepared to do that today. So
Well,
that's your options.
Let me say, we have provided proof to your office that the person that got in the accident was compensated by his insurance. Would you be willing?
Restitution.
Yeah, would you be willing to do a dismissal upon payment of the court costs, which he would do today?
Glad you're okay.
Okay. Why don't we set it for, do you have a judge trial date, Judge?
We can set it for a judge trial date if y'all both think you're ready for that. Certainly, sure. Mr. Saunders, I know that you won't be here next month.
So this guy fell asleep,
What if we
hit
picked the date
somebody.
during that judge trial week? We set it for
Didn't
case
know he
management and set it for the judge trial week. And then if it's not resolved on case management, you can appear by Zoom. And if it's not resolved, then we'll go ahead and have the trial already set, a bench trial.
One would ask with the withhold.
Mm-hmm.
Is that leading towards points on my record, or it's just?
Well, withhold is no conviction on your record.
Okay, so what,
It wouldn't be any points with a judge.
No.
If you want to resolve it, we can resolve it. You just waive your right to a trial.
I just pay my fine.
Yeah, pay your fine is over with.
Yeah, I'd rather pay my fine and just.
Get it over with?
Yes, sir.
Okay.
I mean,
Yeah,
is that
I would
leading up to
too.
Any points like?
No, you're not gonna have any points. You will have, if a job application says, have you ever been convicted? The answer is yes, because of your DUI.
Right, oh, yeah.
Okay, but the answer to this charge, if you're on withhold adjudication, the answer would be no. But if a job application says, have you ever been charged? That's a different question. Answer to that would be yes.
Right.
If a job application, state of Florida applications, I think say the following: have you ever been convicted or had adjudication get withheld? The answer to that would be yes, because adjudication get withheld.
Everyone
But what
I
I'm
ever
saying
saw
is your
always said,
DUI
have you been
was more likely to hurt
have you been convicted of a felony? Is typically what they say on the ones around here. Just saying.
you than this. I
Only
cannot
felonies
tell you
count.
how an employer will look at this. It is what it is. It's the lowest degree crime level we have in Florida. It's just higher than a speeding ticket. And if you want to talk to your attorney in private, that's perfectly okay. If you have questions, and I'll call you back up in a little while if you want to talk to your attorney. We've got a room
When
over
Cree
there. You can
gets
talk to
back,
him in
we'll
the jury
jump
room
over
if you
there.
wish.
Thank you, Terminator.
We're just going to enter no contest plea, Judge. Get it over with. Thank you.
And Mr. Simmons, we've got a waiver of rights form for you to sign. Mr. Simmons, this waiver of rights form does a couple of things. It waives your right to a trial. It also waives your right to call and cross-examine witnesses at a trial. There's no trial. So since you don't have a trial, you're waiving your right to call and cross-examine witnesses, and it enters your plea of no contest.
Okay.
And we'll put this on the plea form. If you find out this is somehow negatively affecting your employment, then I will allow you to withdraw your plea. Mr. Saunders, any objection to that? We're not trying to hurt your career. So if you get over there and your principal says, hey, this is a problem, then we'll put on the plea form with Mr. Weaver's agreement that I will allow you to withdraw your plea if that happens. I don't think it's going to happen, but if it does, that's not what we're trying to.
Let me explain that really quick. If you take Zoom court and you record it, and then you use it towards a court case or in some sort of way for, what we do is okay. As far as, it's not like, you're going to get arrested or anything like that. It's more of, okay, we're using this as educational reaction type thing. When they say that kind of stuff, they're more talking about the prosecution, the defense, people recording it and using it against someone. That kind of thing is more about what they're talking about. So there's a thin line when it comes to what you're allowed, not allowed to show, and what when they say you can't record this, they're talking to someone who's involved in the case or might be using it against someone.
Accomplish. Okay, sound good? All right, so if that's what you want to do, just sign that waiver of rights form, please. And Dolan, please add that.
This guy's,
language to the plea
yeah,
form.
he's definitely doing the right thing by go ahead and doing this. Get it
And-
over with.
Mr.
Oof.
Weaver, what will, Mr. Simmons and Mr. Weaver, what I'll do is I'll just put, within the next 60 days, if you wish to withdraw your plea, no questions asked, I'm gonna let you withdraw your plea and go back to square one. So you got 60 days to make sure it's not gonna affect you, okay? All right, so I'm gonna show a plea of no contest, Mr. Simmons, in 22.
Exactly.
114. To
The
charge of
show
leaving scene of
is
accident without giving
for,
appropriate damage
you know,
required by Florida
education.
law, withhold
You
adjudication.
guys are all
of guilt,
learning something, right?
impose a standard court cost and fines. Actually, I'm gonna sentence Mr. Weaver, Mr. Simmons to 10 days in jail.
Take
But
care,
Will never
Snoopy.
serve any of that sentence as long as he pays the court costs and fines. In this case, there are, did you say
$308, I believe.
they're 308? It's kind of a hybrid. This charge is a little unusual one. $308 is due by June 14th. Mr. Simmons, I always put on here a court date to come back. The reason I do that is if someone has something come up and they can't get it paid, I want them to be able to come back to court and say, Judge, I was in a car accident. Judge, I got laid off, whatever. So if you need, we need to make sure we add that comeback date and the language about the 10 days. It's usually the next day after the due date. So the due date, Dawn, is. So if you need an extension, you come back on June 15th and say, Judge, here's what's going on. I need a little more time. If you get it paid by the 14th, you don't come back to court. It's only for people that need it. So even though there's a court date on there, read it carefully. It's only if you need it. And did we add the language about the 60
It's
days?
self-explanatory
So-
there.
Judge, if there's a clerk's office, I think we're planning on paying that today.
Yeah, well,
Downstairs. Thank you very much.
Thank you, Mr. Weaver.
Nice seeing you.
All right, looks like they're
Sir.
done.
Thank
Let's
you.
head over to everybody's favorite, Judge Porter.
Brian?
Judge Porter. Yeah.
Okay. I lack jurisdiction. Thank you, Mr. Masick. Thank you, Mr. Morris, for your integrity.
Somebody actually had
All right.
integrity.
Ashton, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney and your attorney, Edwin Youngblood. Edwin, are you here today? I have not seen you
Youngblood.
yet.
That makes me think of Dog the Bounty Hunter every time. Me and Youngblood are going to be hunting down this.
All right, I'm going to ask Larry Beaver, another
Revocation.
who regularly represents kids in our court, to step in for
And,
Mr. Youngblood.
and
this
that's
afternoon. Mr.
exactly
Beaver,
what
how
it's
are you?
for, is stuff like that.
All right, Ashton, you're currently on interim supervision from Denton County for felony offense of credit card abuse. You're level 2, unacceptable in the back. The court's previously found that probable cause.
We
exists
watched
to
it, Eric.
believe that you may have engaged in
Right
delinquent
there with
conduct.
one of his two
All those
phones.
factors put together mean I can't release you today, so I got to keep you here.
Exactly.
You need to get to level 10 for me, okay?
Well, we got a second
Thank you, sir.
while he's doing that, and he's going to read some more. I wanted to say
Stolen
so-
credit card.
So we looked into it because almost every single one of these has that, you know, in the little do not record and all of that. So we wanted to look into it to make sure that we were all right, because you're messing with some, you know, stuff here. One thing I want to say about Judge Kim and Judge Porter, there's a Q&A on their channel, which I think you should go and watch. It's actually pretty damn good. If anything, they're going to say this, and they've said it numerous times. They want more people to see this and understand what's going on and get a better idea. And that's why they're continuing to do the YouTube thing. They explain it really well. And it's pretty interesting. Whoever this is level 10 for a while.
Hell yeah.
For 2 different felonies. And
Make sure you pick up your level 10 shirt
failing to
over on our store.
Do we have one?
Based on that,
Yes.
I'm find that if I release you, you're likely to abscond from
I want to see it.
the court. We'll see how your hearing goes in front of Judge
Exclamation point merch in the, or can you just pull it up?
I'll pull it up and show it to you.
Thank you, Your Honor.
Caden.
Damn, moving them through quick. I got to get a Mountain Dew. I forgot it.
Caden, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Vicki Wiley, is here. Good afternoon, Ms. Wiley. How are you?
Good afternoon, Your Honor. How are you?
Better than I deserve. All right, Caden, you're here on an EM violation that we received a report that you violated your EM about 3:18 in the morning back on March 31st. Officer made a home visit and found you outside of your home. You were working on somebody else's motorcycle at the end of your driveway.
Your Honor, I think that actually happened around 3 in the afternoon, but he was brought in the morning late. He was like logged in late at night.
You are correct, Ms. Wiley. He's brought in at 3:15 in the morning. Okay.
Prime time for fun is what we say.
Got nothing bad to do. It's fun.
Yeah.
Yeah. Oh,
Now I
yeah.
remember Judge Kim.
I remember you. That's never good.
Yeah, I remember the initial detention hearing now.
Oh, that's not good. When you see that many kids, that's not good.
Then you refuse to go to school because it's your birthday. You don't get to go. You don't get to choose whether or not you go to school on your birthday. The answer is you always go to school on your birthday.
I realize that. Sorry, sir.
Remember, you have the right to remain silent. Okay. We got a DA who's listening in. Anything you say could lead the DA to evidence to use against you. That makes your case worse.
Sure.
But if you keep silent and you only say what you're thinking to Ms. Wiley, that makes your case better because you're helping, helping the DA, right?
Indeed.
All right. You've been level 1-0 since the 4th, so he's got 10 days.
I love that.
Ms. Wiley, what are your thoughts?
Well, Your Honor, he would like to go home to his mother. I don't know how his mother feels about that because of the latest issue.
It's not an issue. It's a full magazine subscription.
Thank you.
So, Mom, what are your thoughts?
I am not joking when I say this, Your Honor, but I'm hoping third time's a charm. If he can, hopefully learn from this time, I wouldn't mind him coming home. But also at this point, if the behavior continues, he will be moving to either my father's in the middle of nowhere
J. Stephen O'Neill,
or his dad's.
Holding it down in Canada. Good to see you, buddy.
Ms. Howell, help me out.
Sir?
Ms. Howell?
Yes, sir. Can you hear me?
Yes, ma'am. Help me out.
I'm not sure here. Caden knows the rules. He's perfectly capable of following those rules if he chooses to. Mom is very good about keeping me informed. So I'm not opposed to trying it again on the EM if he understands that in the house means in the house.
And go to school means go to school.
Exactly.
It was his birthday, and he is laughing about it
Your
right
Honor.
now.
He is. That doesn't help him much.
I don't think he realized the driveway was off limits because we did discuss with his PO. I'm not sure about the public defender that he does work on bikes as a job and income. So that person that had came to the house was picking up a bike that he repaired in the garage and he was helping him load.
God, really? We do. Gee.
This just then.
I wasn't
Breaking
there
news.
that day. I was at work myself. So
JG, did you see we had these shirts available?
Why are we making excuses?
I want one
I'm
of
not
those.
making an excuse at all. He knows he's not supposed to, but I just think he was trying to help the guy load the bike.
Wait.
and I wasn't-
You just said he knows he's not supposed to.
Well,
and then two seconds earlier, you said maybe he didn't know. So
Well, I'm saying not the house.
She was doing so
property.
well.
She opened her mouth though.
Mom, I'm not going to talk over you. You show me the same respect.
Absolutely.
Mom, stop making excuses for him. You told me in one breath that he knows
Hello?
better. And then in another breath, you said, well, he didn't know. It sounds like you're trying to minimize his behavior and make excuses for him. No, the rules are the rules. He either needs to follow the rules at your house, obey the rules as explained by Ms. Howell, or he needs to stay here in detention.
Hello?
You don't need to make excuses. Okay, we're not going to talk over each other.
Hello?
Are we clear?
Well, that comes under the category of too bad.
Does she want the truth or
You
not?
can't
handle the truth. Then he needs to stay here. If you can't make sure that he understands the importance of following the rules, if you want to minimize his behavior, if you want to make exceptions for him, sounds like he needs to stay here.
Once again, the communication process is broken down.
These rules are black and white. There's no gray area.
Understand?
Oh my goodness.
Listen to me.
Leave him there, Judge. Don't.
Okay, that means you can't walk outside of the garage. You can't step off on the front porch. Even if your mom thinks you're just trying to help somebody. No, what
Do you
I know
understand?
what you're doing, you're trying to push the boundaries. See how far you can get before you get in trouble. I know. Your mom make excuses for you.
Why
but
don't you
I
pay
won't.
attention?
Ms. Wiley won't either. Ms. Howell won't either. We know the stunt you're trying to pull.
That's baloney.
That's because I can step back and be objective about this. And I know what you're really doing. I used to be a teenage boy too. Okay.
Yes.
She put her in her place.
Outrageous.
If you think he deserves a chance, I'm going to give him a chance.
Good.
Yes, sir.
Best
When?
one yet.
Okay.
Where?
Back on the electronic monitor.
What?
You violate it by even 6 inches, you're coming back to detention. No ifs, ands, or buts. And next time, you will stay 30 days at level 1-0 before Judge Porter will consider you for release.
Oof.
All right?
Yes, sir.
Okay, that'll be the order of the court.
Yes.
Thank you, Your Honor.
You fibbed.
I don't like your attitude.
Oh, I don't believe a word of that. Thank you
Then
very
show
much.
we get stir crazy if you haven't noticed.
Towards the end.
We hold back as much as we can. As much as 6
Okay.
inches.
Caleb. How you doing, Caleb?
That was lucky because the beginning didn't seem too good
Caleb, we know each other. My
for
name's
that.
Judge Porter. The law
No.
says when you're
I
brought in-
thought he's going to let him go.
You must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent.
Explain
You
that
also
to
have the
me.
right to an attorney. And I believe your attorney, Raymond Daniel, could not be here today. So I'm going to ask Larry Beaver, another attorney who regularly
Nice
represents the
Beaver.
court, to step
The
in.
Beeve.
Daniel. Caleb, I know your case real well. You're just waiting for transfer to placement. Everything going well in the back for you?
Not really.
Have you been talking to Miss Castillo about any problems you may have?
Yes, sir.
Okay. Ms. Castillo, has he been talking to you and keeping that line of communication open with you?
Yes, Your Honor. He's been
Oh.
very, very talkative with me and has informed me of some things. Yes.
Okay. Well,
Barber's,
Raymond, you did make it. Good
at
afternoon,
Disney
Mr.
World.
Daniel. You're on mute.
Took some time off.
Nice chair, Raymond, by the way.
Still on mute.
Okay, there we go.
All right. So, Caleb, I've got to keep you here just a little bit longer. I know Miss Castillo checked earlier this morning about when you might have a date when you're getting ready to go to placement. So she's watching that date for you, okay? All right. Thank you, sir.
Well, Caleb seems like a nice kid, right?
Speak.
He sounds like everybody's picking on him, though. Give him more time inside.
All right.
Why?
Devonta.
And Judge, it's pronounced Cavante despite the spelling.
Oh, thank you. Are you Cavante?
Yes, sir.
Cavante, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This
You're
is your 10-day
irritating me.
hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Raymond Daniels,
You're
here.
an
Good
idiot.
afternoon, Mr. Daniel. How are you?
Good afternoon. Just fine.
You're
Thank
a
you.
moron.
All right. Cavante, the court's previously found that probable cause exists to believe that you may have engaged in delinquent conduct, more specifically capital murder. You got a hearing in front of Judge Kim, certification hearing, and then trial is scheduled for September 19th. You've been level 1-0 since March 28th. However, because of the seriousness of the offense, I'm going to keep you here a little bit longer as a danger to the community. Thank you, sir.
These biscuits. Hey!
Capital murder
Period.
every time. But at least he's been staying 1-0 for quite a while. Speaking of that, Creed, would you say we had these amazing shit available in our store?
Harry, my name is Judge Porter.
The hell
Law says
happened
when
to
you're
you?
brought into
That
detention
was
and
weird.
initially detained, you must see a
What?
judge every 10 business days thereafter. This is your 10-day hearing.
Your voice
You have
did
the right
something
to
very
remain silent. You
loud
also have
and
the right
weird.
to an attorney, and your attorney
Oh,
can't
hell.
it's here. Good afternoon, Ms. Taylor. How are you?
I'm well, Judge. Thank you.
All right. Terry, and the court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention, more specifically, both theft and capital murder. You're level 1 acceptable today. You know that if you're not level 1-0, I cannot release you. And that, given with the gravity of the offense alleged to have been committed, I'm going to find that I need to keep you here today. Thank you, sir.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Good to see you, Ms. Taylor.
You too, Judge. Thanks.
All right. Roger in.
Let's watch one more, and then we'll move on. Richard Gladstone's ear is popping pretty good.
Are you Roger in?
Yes, sir.
Richard, put it right inside your ear.
The law says when you're brought into detention,
I feel like I'm inside Richard right
the
now.
judge every
I
10
do.
business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And I thought your attorney, Richard Gladstone, was here. Mr. Gladstone.
Oh, he is. His
here.
ear is here.
There he is.
Oh, nice mask, Richard.
We'll let him get settled.
Well, they got different levels as far as your behavior goes, and they want to see a level 1-0. That's the best you can be.
That's
And they want to
outstanding.
see
by
you
the
there
way, yeah.
for a set period of
Mr.
time.
Gladstone.
Good afternoon, Judge.
All right, Roger, and you've been level 1 outstanding since April 9th.
There you go.
You got a hearing scheduled in front of me next week, and you're on probation for evading arrest with Judge Terry. More recently, you were referred in custody March 30th on a DTA issued by Judge Terry due to you testing positive and being suspended from school for fighting while court was pending.
Are we going to what you got up now, or are we?
Um,
you gonna?
I'll switch it, I guess.
Judge, he's got a hearing coming up, and I understand that he's been brought in on a DTA, but it's, what can I say? It's not another offense in a sense, it's just technical. I'd ask he be released and see how he does between now and then.
We've heard that defense before. It's just a
What
technicality.
we need to do next week.
Technicals.
Remember that?
Are you here?
Mm-hmm. Just technical.
Now, Judge Terry placed him on probation in November of last year. Am I remembering correctly?
Yes, sir.
And then in December, he picked up a new assault family violence. Is that correct?
Yes, Your Honor. And we all
Alleg-
had a-
allegedly.
Allegedly, yes, Your Honor.
Okay. And that new assault family violence hasn't gone to court yet, correct?
Not yet, Your Honor.
And so while he has an old case, picked up a new case 30 days later, and then he comes in March and he's testing positive for drugs and he's been suspended at school for fighting. Am I getting my
Yes, Your
timeline
Honor.
correct?
Yes, Your Honor. Correct.
Mr. Gladstone.
It's not a good record since he's been on probation, Judge, but again, these are misdemeanors and kind of minor technicals, so kind of reiterate that I'd like to see how he does between now and then, maybe get back to school and impress the judge in the next few days.
Impress the judge if he could.
Have you read the detention hearing report, Mr. Gladstone?
I have.
Did that suggest assault on a female?
I have.
I understand, Judge.
It's a technicality, Judge. Judge, it's a technical thing, Judge.
Judge.
Just a misdemeanor, Judge.
Recent UAs were positive for marijuana.
Technicality.
Yeah, Rodrian. I'm afraid if I let you go, you're likely to hit somebody or use drugs.
Allegedly.
But your
Let's wait and
honor.
see how next week goes. All right.
I understand, Judge.
All right.
Just
Next week he
technicality,
goes.
Judge.
He's going before the judge next week for a trial with Judge Porter.
So good luck with that.
We started here, we'll end here. Me.
What are we listening to things in court?
We listen to like a recording from.
Yeah, I think so.
All right.
Sir, I would like to ask, what time can I get my bag back? You know, I had like in my car. Correct. And the car back to Mr. Morrison? No, it's not in the condition to go back to Mr. Morrison. Okay, then I'll just pay for that. So yeah, it's okay, Morrison. Yeah, it's okay. It was no value car, so it's not much. But
Just because this is hard to hear.
It's so
Yeah,
hard to hear.
let's go over and see Judge Mary Brown.
Without seeing.
Who dis?
I'm also not going to advise.
I don't know,
her
but
and just deal with the kid issues later and go ahead. and do
Yolanda
it.
is in a massage parlor.
I don't even know right now. You
Possibly
said
an
child
Asian
support order. It could be a divorce. Like I don't even know what it is because I don't have it. We'll
I
see.
understand that, but it's not.
Good luck, Street Grind.
Well, have you seen it, Mr. Nduku? Have you seen it, Mr. Nduku? Yes.
You have just a regular copy of it, of some of the paperwork, Mr. Ndukwe? Not certified, but just any copy of any order from North Carolina?
No, you're not the
North Carolina.
one I have. One I was telling you about the
Raise up.
Attorney General. And the only reason I found out about it was because they contacted me in North Carolina and told me there are two orders, one in Texas, one in North Carolina. And so that's the only reason they gave me the number. I don't have the order. That's how I became aware about this because we came here in Texas and I get a temporary order. Then I subsequently find out that there is an existing order in North Carolina. So that's how I got the number.
I would say so, and she has terrible taste in paint colors.
That's the same color that one guy had that was sleeping on the couch yesterday, rubbing his dog.
That's
and the reason I know it wasn't a divorce was it came from Attorney General because they told me that they initiated it.
It's a great movie.
Do you but now has your client relocated back to?
Yes, Your Honor. Yeah, she came.
I can see Moto G coming and trying to break my leg with a baseball bat for not paying my sports debts. You know what I mean?
Yes.
So
I like that their interpreter is quiet. We can even hear what she's saying. I like that.
I see you got your counterclaim in, Mr. Sullivan, on April 7th. So it's not like they can just
So you're just listening.
and away.
Here's the tricky part anyway, Judge. At this point, this court made the last valid custody determination. And if it had jurisdiction to make that, then this court now has continuing exclusive jurisdiction, regardless of the fact that that's a temporary order. And there's case law on that. And regardless of if the case was closed by a non-suit or any other method, Texas would now have this court would now have continuing exclusive jurisdiction until either everyone moved out of Texas or this court ruled that it no longer had jurisdiction.
So amazing how much
Sullivan, there is no
stuff goes into just getting to a case. Getting to that point.
So as a matter of law, there is no court order. There is an associate judge's report. There's a child custody determination.
Yeah. But without full, I mean, obviously we don't have all that information. I'm pretty
All
sure.
right, we're not getting anywhere.
Mr. Niner asked me to convey he's feeling
Niner.
Niner in the house.
Okay.
No, Ghost, not no.
It happens.
Partially because these are all in other states too.
But we did run into, somebody said earlier they knew
When
the
it happens to me, I
lady.
usually just put on my, what is it called on your phone where you just use your.
Well,
we're waiting.
Let's see here.
Terminator said we missed good when we left Porter too early.
Yeah, that's how you can sit there all day. You guys see
Ryan
bangers, as they say.
Deputies, I'm waiting on his signature for the special condition. He signed a defendant waiver, but not the special condition.
Oh my God, look at that big ass cup. Bringing up our next contestant. And she seems like a nice girl. You take her to meet your mom.
And who is this? Okay, we just needed the other person to sign the special conditions, the one we just handled, Mr. Robbins.
Terminator, how far back?
It had to just happen.
Well, it's got to be like the next customer, then, right?
Has to be.
Oh, I see. Okay. We'll watch.
She seems like a nice girl you want to introduce to your mom.
Maybe I'll come back and request the judge to make that decision. I'm sorry, Judge.
Who is?
I'm not making this out of an argument.
All right, so it was right after we left, the very next person after we left.
For
Okay.
Judge.
Yes, ma'am.
You had told me when she have her psych evaluation, you was gonna let her
So
go.
it's this lady.
You did that yesterday. She did everything
next
you
time.
asked her to do. She been on medications for about 3 weeks now. I gave them to the nurse.
Judge, I don't have the result of the evaluation. It was done yesterday. So I don't
Same
know
guy
what
from the other case we just saw
doctor
in
is
the other
reporting,
courtroom.
but I'll be supportive of the mom's request to let her go home. But we need to see that evaluation first.
Okay.
What about a leg monitor that you promised me, Judge Porter?
Ma'am, are you listening to me?
I'm talking to the judge.
Okay.
You keep
Go
trying
ahead.
to keep her here, and you tell me one thing, and then we get here, you do another.
Ma'am, you're not making a good case for her to go home. Did you listen to what I said to the judge, and did you hear the judge's response? The judge gets to decide whether she goes home or not you.
I'm not making this out of an argument.
You are.
I'm expressing how I feel at this moment. I feel like I should be able to speak how I feel.
You did speak.
Mom's is tripping. I gotta go home.
Anything else, Mom?
No. So what is next? Another 10 days, and you tell me the same thing?
Uh-oh.
Okay, best part about this is when you rewatch it again and you see everybody react to it on the
You see
screen at
Morris
once.
step back. He was like,
Yeah, Morris like you just know that you're at a point where it's like, you know,
it's about to happen. It's about to come down.
Another 10 days?
Watch.
You tell me the same thing?
Watch everybody else.
Judge, can I request that we get the report, and then maybe I'll come back and request the judge to make that decision. I'm sorry, Judge.
Who is in the family room?
Supervisor Robinson.
Miss Robinson, would you get with Deputy Self, and so that he can escort that mom into our little holdover room, and I'll talk to mom after we're done today.
Yes, sir.
Give her an opportunity for her to explain why she should not be held in contempt of court.
Yes, sir.
Thank you.
Thank you, Judge.
Thank you.
She's going to learn a lesson, I'd say.
Oh, look, the daughter's crying.
Yeah.
Easy.
Yes, Your Honor.
I mean,
Once you have that report, let's schedule an attorney requested hearing.
I will do that, John. I appreciate that, Judge.
All right. Thank you.
feel bad for the kid.
Your Honor, I am subbing for Ms. Morales, or Perales, just to let you know.
Are we going to say anything to her? Or is she...
Say something, Judge. Come on.
Well, hopefully we can get her out and bring her back in.
Awkward.
Oh, God bless America.
Judge Porter, how you doing today?
Judge?
Yes, sir. Thank you, Mr. Adeniji.
Thank you, Judge. See you at last.
Oh, what? The
Amy-
judge just covered his face.
Oh, yeah, he did.
Oh, this is unheard of. Him covering the camera like that.
He's trying not to blow up, maybe. I don't know. That's a big huh.
Judge Porter's having a meltdown.
Judge
Porter left.
What?
Wow. Wow. I haven't seen
Left
that.
right before all the at the fan, you know.
Let's see. Mr. Youngblood, am I going to pronounce your client's name correctly? Is it?
All right, I guess that was it for that. That was
Report, sir.
pretty interesting.
Wow.
Let's watch one more, and we're going to jump. Don't forget the continuation of Wild Women Wednesdays coming up for We Got a Case today.
And one that we missed last night. This is a shorty, but we're going to check it out anyways. Man, that was crazy.
Yeah, thank you, Terminator. That's figures, right?
Typical.
That's all right. Thankfully, we can go back and watch it.
All right, ma'am, you're before the court under warrant, two warrants, 22W005562. You're charged with aggravated assault with a weapon. I handled this warrant. Evidently, you were having some type of mental health episode. You have been diagnosed with schizophrenia, and
hey,
your mom
it's
was
Dave the
just trying to
Fly.
get involved to try to help you. And I understand that your grandmother takes care of you, but your mom helps. So you're charged with aggravated assault with a weapon, and you're also charged with cruelty to child in the third degree because I believe your child was there and observed you hit your mom repeatedly with the iron, causing injury to her.
Iron?
12 cycles of criminal history, mostly mental health issues. 2017 prostitution, failure to appear. Did the state come up with any kind of consent on this one? Her
Prostitution?
mother, I will say, her mother wants contact with her because the mother's mother, this young lady's grandmother's taking care of her. And because she's older, her mom is concerned about her mom the grandmother taking care of her daughter with her mental health alone. So she needs to be involved in the caretaking of her daughter. So the detective specifically asked for no violent contact.
Your
So
Honor, in her criminal history, I believe that there is a pending 2018 charge that may make this Superior Court only.
Oh, really?
Yes.
Okay, what are you showing?
Your Honor, it's a pending 2018 aggravated child molestation.
Whoa!
Was that sealed?
No, Your Honor, I don't show any disposition on that case whatsoever.
Thank you, Dave.
Muchas gracias, Dave.
So you're not showing if She's out on bond on it. If she's been arrested on it. Ms. Thomas, can you look for us? Go ahead, please, Ms. Dunkelroad.
So the file is open or we do have the case in our office. And I did attempt to determine the status of the case. The last update I have on that is a 2021 bond revocation.
Well, I hate to end on this one.
Oh, so she was out on bond?
Correct. And she was supposed to be in a treatment program for her mental health and was not, which was why bond was revoked.
I think that's the same case we're talking about. My understanding that it was sealed.
I don't show any documentation for that, Your Honor.
If it was, it isn't now.
Okay. Could you give me just one, we'll let her have a seat and we'll come back to her, okay? Because I'm going to give my pretrial services investigator, because I'm almost sure she told me that that was a sealed offense. So maybe I'm mixing things up, but we'll come back to that one. Let's go ahead and
iron
handle
on a
Mr.
rope.
Larry Smith.
Feel free to snap as an NFT and share the profits with me.
Niner. Niner's looking red again with the red.
Yeah, the hair. It looks like he's dyed his
All right, and
eyebrows
Mr. Smith, you're
now.
before the court, and your warrant is 22W0.
Hey, watch. Next time we see this, it's gonna be
5562.
completely different area. Look, straight up
Um,
redhead right now.
Oh, I'm on the wrong case. Hold on 1 second.
Is it a
Let me pull your
clone?
charges up. I was still on Miss Slayton's case.
Are they
All right, you're
twins?
charged under
They-
warrant
they-
20W012945. Let's see, it states that you failed to register as a sex offender. Let's see.
Nothing but the hit screen.
Finding all the
And this
good
is
ones
from
today.
August 24, 2020, so it appears he has not reported since then, over 2 years.
Been
All
out
right, so
partying.
the offense happened in 2005. There was a failure to register 2006, 2012, 2017, and there was a
Uh-oh, I
violation
forgot.
of probation in 2007. So what's the state's recommendation on this one?
Your Honor, the state's recommendation is $2,000 with the condition that he register.
Okay, all right, that's reasonable considering everything. Mr. Niner?
Judge, I just want to point out, so today,
Here it
is
comes.
Mr. Smith's birthday. As you know, they have to register around their birthday. So that is why he was at jail to register. That's why he's in custody right now. So he did not realize there was an issue with his registration. As you can see from the warrants, he's had to register every year since 2005. I do see on his record, there is one other from about a decade ago, similar situation where it was just a miss up where he failed to register. Your Honor, he's not trying to evade registration. This was an accident. He explained it to me. He moved.
And Rafa's birthday today.
I'm asking for UJR. He went to jail to register. He had no idea there was an issue with his registration. He's been doing it for over 8 years, and it was just an accident. So I'm
All
asking
right,
for.
so where is he living now?
He lives in. I can put the address into the chat if you'd like. It's here in Georgia. It's in Stone
Okay.
Mountain.
Okay, so I'm gonna go ahead, and this is about the third time this has happened. People go in and they get arrested, so good faith effort to comply. I'll grant him a UJR, but special conditions shall not be released without registering as required by law, okay?
Thank you, Judge.
You're welcome, no problem. All right, and we'll have you sign your special conditions. I'll let you be released without posting bond.
One more.
As well as you'll have to sign a
Good,
defendant
good.
waiver because
Sounds
you
good, yeah.
you don't need a preliminary hearing.
Just because Niners are redhead today.
Looking so good. Knox's brothers here.
Give me a moment, everybody, let's just take about a 5-minute recess if the case
Oh.
needs to grab water.
Oh, I
We can
guess
get
that is
Nope.
it. And we are gone. Let's see what's happening here, though. Real quick.
Counsel, the arguments in opening, the arguments in closing, and the questions of counsel are not evidence. They are rather, as we all know.
We missed it just a few minutes ago. Janet there was very mad, very animated. Anyways, hey, another great round. Oh, I love that shot. I wish they'd keep that more often there.
Look at him shuffling. Every day I'm shuffling, shuffling.
He's mopping the floor on his way in. Isn't that an as seen on TV thing? The sandals or whatever, the slippers, they have like the. Anyways, guys, thank you so much for joining us. 2 hours plus of live courtroom drama folding in front of our very eyes. I love it. We'll see what happens tomorrow if there's no live court, which would make sense because it is Good Friday. we got lots to go and watch. Lots
Don't
to
you
bounce
worry.
around and watch. We will be back with you at 4:05. Again, the continuation from yesterday of We Gotta Chase, Wild Women Wednesday. And Mikey, you said a real short one from last night.
A real short one from last night. Cut out the part where you hit a dog. I'll go ahead and say it now. The dog is not fine.
But we won't be seeing that part.
Does that mean my stock in Twitter is going to be worth more? I've got a share.
Exclamation point merch in the chat.
You can get this shirt on a mug. You can get it as a
love it.
sticker, whatever you want. There it is. Check it out. And $3 of your shirt purchase goes straight to us.
Keeping the costs low.
All right, guys. We appreciate you all stopping by. If you haven't already liked this, please do so. Creed, anything else?
Yeah, but it's all blown up, and is that what you're talking about, James? What they like blow it up so you like, oh, it's weird. The jail court thing.
The one that the guy does, what is it, bond court?
Yeah,
I love that.
Yeah, but I it's just that it's the way that he has to blow everything up. I love listening to it. Do you know what I'm talking about? Like making it just like everything's like
right and
wonky. Which one's Chicago though?
I don't know.
Live jail court. Is that true, James? If that is, send us a link to that. I want to see how
I definitely want links to that. All right, guys. If you ever come across a courtroom that you don't think we have, send it over. We would love to watch it. Well,
and the other thing too is when you guys, because I know lots of you do, just like me, when you're watching, even without us, and something happens, there are some courts you can just jot it down, what it is, when it happened, something that we might want to see. Feel free, and that's another reason we got a case on Discord, or you can of course email us.
Yeah. Don't forget, that's always the beginnings of We Got a Case After Dark. Until next time,
Like trains.
please remember.
Oh yeah? Well, screw you guys. I'm going home.